Good morning, gentlemen. I just wanted to tell you if we need to work late or something to accommodate the schedule, that's fine with me. Just as long as it's okay with the parties, you guys do what you got to do.
Thank you, Mr. Lee.
You bet.
I hope that's not the case.
I'm easy either way.
Sure, thank you.
Morning, Chris. Morning,
Morning.
Mr. Lee.
Good morning, Judge.
Thank you so much for offering. I was right here, but I didn't have my headphones on, so I couldn't respond right away. But
It's
I
all
appreciate
good.
you off. Yeah, thank you so much.
Good morning, Mr. Medeiros. Peter Gould. Can you hear me?
Yes, sir. Good morning, Mr. Gould.
I didn't want to interrupt the flow of the hearing this morning, but so I want to just bring it up. Do you want us to reconsult with our expert witnesses and get some updated times from them on when they might be available? We forwarded you an email from my co-counsel,
Yes.
Kelly Gould, and that was the latest that we knew last week, but everything may have changed as we go forward. So I just wanted to bring that up, but okay.
Yeah, and I ask all the parties, if you're listening in or on here now, that you please check with your witnesses to see how flexible they are to be moved into different slots, because the lineup will change as we move along. But hopefully this morning we'll be starting with Mr. Casas. But before we do that, let's go ahead and go on the record, Mr. Lee.
Go ahead.
Good morning. This is day 8 of the hearings in the PNM rate case, case number 22-00270-UT. Before we hear the evidence from PNM from its next witness, I'd like to see if the parties have any preliminary matters they'd like to address. Mr. Albright, good morning.
Good morning, hearing examiner Medeiros and Mr. Ryan. Just a quick question as to whether or not the parties need to be available on Thursday for the commission's discussion of the settlement agreement with regard to the San Juan. Obviously, that also affects the rate case, and I didn't know if we were going to get any guidance or not get any guidance, or if we're just going to proceed with our with the rate case proceeding on Thursday.
I recommend that you have one ear on that and one ear on this, unless you're actively participating.
All right, sir. And I will also be checking with my expert to see how her other proceeding is going. She may be available at the end of this week instead of on the 25th, but I will check with her and get back to you within the next day or so.
Okay. Thank you, Mr. Albright.
Thank you, sir.
Anybody else? Sorry, anybody else? Okay, PNM, Mr. Alvarez, good morning.
Mr. Medeiros, real quickly before Mr. Alvidrez, question
Yes,
for you, sir. Would Mr. Sanders or Mr. Gray be the witness to discuss the system benefits of BB2? It's a question. Which one?
Mr. Sanders.
Mr. Sanders. So it's my understanding that Commissioner Ellison would like to speak with Mr. Sanders.
Okay.
So I will consult with Commissioner Ellison at some point this morning before lunch or whatever, and maybe we'll just try to figure out when we can get Mr. Sanders back to discuss that.
Absolutely. He is available, I think, most of this week. So
Terrific.
perhaps it would be good to get him on sooner than later, but yeah, he is available and was anticipating that he might be recalled. So
Thank you
Great.
very much. That's all.
thank you. Are we ready, Mr.? Would you like me to go over our PNM's witnesses for today before we start, Mr. Medeiros?
Yes, please.
So in keeping with the schedule, our first witness today will be Mr. Miller, and he will be followed by Mr. Casas, Dr. Pitts, and Mr. Phillips. I think that will probably provide a full day of testimony. And my understanding is that the Lopez and Maestas testimony will be stipulated in at some point in the near future. But we
Okay.
are ready to proceed with our next witness.
Okay.
And we would call to the stand Mr. Joseph Miller and ask that he be sworn.
Would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter no opinion should be the truth, the whole truth, nothing but the truth.
I do.
Thank you, sir.
Mr. Miller, will you please state your name, your employer, and your job title for the record?
My name is Joe Miller. My employer is Pegasus Global Holdings, and I am president and CEO.
And Mr. Miller, did you prepare pre-filed direct testimony that we filed in this case on December 5th, 2022?
I did.
And can you confirm that what we have marked as PNM Exhibit 19 is a true and correct copy of your testimony?
It is.
And does this testimony include the errata that was subsequently filed?
It does.
And with the errata, is the testimony true and correct to the best of your knowledge and belief as set forth in Exhibit 19?
Yes, it is.
Mr. Hearing Examiner, we move the admission of PNM Exhibit 19 into evidence.
Any objection? Hearing none, PNM Exhibit 19 is admitted.
And Mr. Miller, did you also prepare and file in this case a rebuttal testimony?
I did.
And can you confirm that what we've marked as PNM Exhibit 20 is a true and correct copy of your rebuttal testimony?
Yes, it is.
And is your rebuttal testimony true and correct to the best of your knowledge and belief?
Yes.
We move the admission of PNM Exhibit 20 into evidence.
Any objection? Hearing none, PNM Exhibit 20 is admitted.
And pass the witness for examination.
Okay. Thank you, Mr. Alvidrez. Mr. Herman, good morning.
Good morning, Mr. Examiner.
I see you have 25 minutes with Mr. Miller. Is that correct?
That is correct.
Okay, please proceed.
Good morning, Mr. Miller.
Good morning, Mr. Herman.
My name is Keith Herman, as you caught on. I represent the Water Utility Authority in this matter. I have some questions about your rebuttal testimony, but I just want to start with asking you what materials you reviewed in preparation of your testimony today.
A number of orders from the commission, the 2015 rate case in particular, the orders from that hearing, the Supreme Court decision in that case, other witnesses' testimonies, and many other documents.
Let me parse this out. I'm afraid I might not have been clear. Let's start with the materials you prepared or you reviewed in preparation for your direct testimony.
Yes.
That would be all the cases you identified and other materials provided by PNM.
Yes, let me go to that section. Yes, I reviewed past petitions and testimonies and orders from related to Palo Verde Units 1 and 2. The original cases that approved the sale and leaseback arrangements, reviewed San Juan Units 1 and 2 abandonment cases, the information and communications in the 2015 rate case, San Juan 1 and 4 abandonment cases, integrated resource planning information from the 2017 Integrated Resource Plan, the 2020 Integrated Resource Plan. Much of the stakeholder information from that 2020 IRP process. 2021 proceeding related to the decertification of the 114 megawatts of Palo Verde units 1 and 2. Industry articles, research related to abandonment of power plants across the country.
And then the same question, what materials you reviewed in preparation for your rebuttal testimony?
A very similar information. The topics in my rebuttal testimony are very consistent with my direct testimony. And
additionally, the testimonies you're responding to?
Yes, those 4 in particular I'm responding to, and certain documents and references they may have made in their testimony.
And in preparation for your participation in the hearing today, did you review any additional materials?
My testimonies of others, reviewed some of the oral testimony given by others in this case.
Did you review specifically, and I'm going to refer to commission cases, but they might be public service commission cases because they're older. Public Service Commission case 1995.
Yes.
Did you review 2146 Part 2?
Look. You say case 2146 Part 2?
Yes.
I don't believe so.
Did you review the certificate of stipulation in 2262?
What was the subject of 2262, if I might ask?
I believe that was dealing with continued participation in Palo Verde.
I'm not good on the numbers of those cases. It's possible. Is that an exhibit in this case that I could look at?
I do not believe it is, but for the record, the case title is in the matter of Public Service Company of New Mexico's application for a change in rates pursuant to advice notices 193 and 194. I was hoping that might be a little bit more helpful, but I'll move on.
Okay.
I want to move to your rebuttal testimony now, starting at page 8.
Okay, I'm there.
At lines 1 and 2, you explain that used and useful is not an applicable standard for Palo Verde, correct?
You know, my experience with the used and useful standard is typical to be applied for whether or not an asset should be included in plant and service. And when an asset is no longer in service, then that asset should be expensed, or as in the vast majority of cases with plant retirements, those dollars should be moved to regulatory asset for recovery.
So, and I don't want to misstate your position, but I want to be clear. Are you saying that used and useful should not apply in the event of retirement of assets?
When assets retire, they definitely are no longer used and useful.
That's true. So again, I'll ask, your position is that used and useful should not be the standard once an asset is no longer in service?
The standard for what?
For whether or not recovery should be allowed?
It's very common across the industry if there are remaining undepreciated costs associated with a power plant, that those costs are, in the vast majority of cases, typically moved to a regulatory asset for some level of recovery, even though those assets or those power plants are no longer used and useful.
So you don't think that the used and useful standard could apply in the event of a retirement?
I think it applies in the fact that the asset should no longer be in plant and service.
I see the distinction. So you're saying that the used and useful standard applies in making the determination to retire an asset, but not on a determination for a reg asset or liability.
Well, when a power plant or an asset is no longer used and useful, when retirement occurs, the asset definitely moves from plant and service to either expense or a regulatory asset for recovery. That's been my experience with the used and useful standard.
Were you watching the hearing earlier for Mr. Sanders' testimony?
I watched a portion of Mr. Sanders' testimony, not all of it.
During my cross-examination of Mr. Sanders, I did ask him if the commission, I asked him if PNM's decision to continue participating in the sale leaseback agreements would be affected by whether or not a reg asset were awarded, and he said no. Would you disagree with that?
Well, are you asking about the retirement or abandonment analysis and whether or not that incorporated recovery of leasehold improvements?
Yes.
In those cases, leasehold improvement costs would typically be considered a sunk cost and would not be incremental in a retirement or abandonment decision.
So you would agree with me?
I'm not certain of Mr. Sanders' response exactly on that, but that would be
simply that the determination of whether or not to continue participation did not hinge on whether or not the reg asset would be allowed.
correct. Those retirement and abandonment decisions typically would assume those type of costs to be sunk and not incremental in that abandonment decision.
Now, I want to go to your rebuttal testimony at page 12, where you rebut Mr. Garrett's testimony. Now, that's our witness, Mr. Mark Garrett,
Yes.
on his interpretation of PRC case 15261.
I'm there.
And you quote the 15261 order at lines 9 through 15, noting that the Palo Verde capacity has always been used and useful, correct?
Yes.
And then you note at you quote the recommended decision at page 108, noting that the commission stated, since Palo Verde units 1 and 2 will continue to serve ratepayers should continue to pay some costs associated with the assets.
Yes.
Do you have access to Mr. Garrett's testimony?
I do.
could you pull up ABCWA Exhibit 1? I believe that's the direct testimony of Mark Garrett.
I have it opened.
At page 27 of his direct, he states that the commission did find PNM's decision to extend the Palo Verde leases imprudent. Is that correct?
Yes,
And one of the reasons for that imprudence was that PNM failed to consider alternatives. Is that correct?
that's correct.
And another reason was that PNM failed to provide a quantitative analysis showing that the leases were cost effective, correct?
Yes, that's correct.
So in its final decision in 15-261, the commission also agreed that the decision to extend those leases was imprudent. And the part of the recommended decision you cited didn't change that, did it?
Could you ask that question again, please?
In the final decision in 15-261, the commission agreed that the decision to extend the Palo Verde leases was imprudent, correct?
Correct.
Did anything in the recommended decision change either of the bases in the corrected recommended decision that I just mentioned?
Well, it's from my review of the 2015 case, as you mentioned, the commission found the acquisition of the 64 megawatts and the extension of the 114 megawatts in terms of the lease extension imprudent, in that PNM did not conduct a rigorous enough alternative evaluation. And but I'm not aware of any finding of imprudence in that case that impacted the leasehold improvements that are at issue here.
You just testified it was with respect to the 114 megawatts and the 64 megawatts, correct?
Yes.
And isn't the 114 megawatts the specific lease we're talking about? Or are you parsing out the leasehold improvements?
No, we're talking about the lease extensions, and I believe the 64 megawatt acquisition from Unit 2.
But then you contended that failing to consider alternatives was the reason, or was the basis for the imprudence in not making the investments.
Yes, my understanding, it was that there was not enough robust analysis of alternatives prior to the acquisition of the 64 megawatts and the Unit 1 and 2 lease extensions. At least that was a part of the reasoning.
Now, in the recommended decision in 15-261, the hearing examiners did recommend a cost disallowance with the lease extensions, correct?
It's my understanding they recommended a disallowance of the lease expenses, but they did not recommend a disallowance of leasehold improvements, is my understanding. Recovery of leasehold improvements.
And do you think it would be fair to conclude that the commission did allow PNM to recover those costs because the Palo Verde assets were being used and useful?
I'm not certain of all the reasons for that. In that case, I know there was a significant disallowance, I believe an $80 million disallowance for the Unit 2 acquisition. But the only remedy for any imprudence related to Unit 1 and 2 lease extensions, I believe, was the order that stated the PNM should not recover any additional decommissioning funds should that be needed in the future. And so in the final order, the lease expenses and the leasehold improvement recovery of and on those improvements was allowed to be recovered by PNM.
And going back to the language you quoted on page 108 of the corrected recommended decision, the commission stated, since Palo Verde units 1 and 2 will continue to serve ratepayers should continue to pay some costs associated with the assets.
Yes.
So the fact that it was used and useful seemed to play a big part in the commission's decision.
That appears to be a part of that decision, yes.
So going back to your rebuttal at page 8, where you talk about the used and useful standard, what would stop a utility from applying this standard simply by retiring its entire production?
Not sure I understand your scenario that you're mentioning.
Well, if a utility wants to retire or wants to ensure recovery of its assets, but doesn't want to be subject to the used and useful standard, by your testimony, I kind of think they could just, retire everything and move it all into reg asset, and then recover everything through the use or through their reg asset, and avoid the used and useful standard.
Well, I think commissions make their decisions based on the overall merits of a particular situation or case. And so, utilities are not guaranteed recovery of remaining investments, but it is certainly common in the vast majority of abandonments and retirements that I've researched.
I want to move on in your rebuttal to page 6, lines 13 through 16.
I'm there.
Let me catch up with myself.
Sure.
About 4.5 minutes, Mr. Herman.
Thank you, Mr. Examiner. I'm sorry, I was on the wrong page. Page 9, lines 13 through 16. You state that Mr. Garrett, that Mr. Garrett is being inconsistent to argue that a return on regulatory liabilities is not a violation of his view that New Mexico is a used and useful state, but that a return on regulatory assets is. Is that correct?
Yes.
Do you understand that used and useful is a standard applied to items in rate base that increase rate base, not to items that decrease rate base, such as regulatory liabilities?
I'm not sure I understand that question.
Let me ask it differently. And you mentioned you had researched other cases. When have you ever seen the used and useful standard applied to a regulatory liability?
In my particular experience has been predominantly around recovery of remaining investments upon retirement of power plant retirements and abandonments. And so I do not have a significant amount of experience with regulatory liabilities. I know that's at issue in this case related to the timing of the lease terminations.
So how would it be possible that a used and useful standard would ever be applied to items that decrease rate base, like regulatory liabilities?
I would have to think about that more. Nothing comes to mind immediately.
So if a regulatory liability is a refund of money collected from ratepayers, how could that ever be determined used and useful?
I'm not certain. There aren't situations where that is possible. Just none come to mind right now.
That concludes my questions. Thank you for your time, Mr. Miller.
Thank you.
Thank you, Mr. Herman. We have the Attorney General, Mr. Elliott. Good morning.
Good morning, Mr. Hearing Examiner.
I have you down for 15 minutes. Is that correct?
That is correct, sir.
Okay, please proceed.
Good morning, Mr. Miller.
Good morning, Mr. Elliott.
I was reviewing your exhibit JAM1, your resume. And I wanted to ask, you worked for Duke Energy from 1991 to 2019. Is that right?
That's correct.
Were you involved at all in Duke's Atlantic Coast Pipeline project?
Duke had the Atlantic Coast Pipeline has quite a history, and the ownership changed over a period of time. Duke was.
Yeah, I just wanted to know if you were involved during your time at Duke.
Not specifically on the Atlantic Coast Pipeline with Duke.
What about the Constitution Pipeline project?
I'm aware of it, but did not work on that while at Duke.
Okay. And I did see that you were involved in some coal to gas plant conversions. Were you involved in the Edwardsport, Indiana project?
My involvement on Edwardsport, I was not involved in the initial development. I was involved in a couple hearings related to Edwardsport.
What about the Lee Nuclear Power Station? Were you involved in that one?
Are you referring to the nuclear power plant that Duke was developing in South Carolina and then halted?
Correct.
I was familiar with it, but not involved directly with that.
Okay. When were you approached to by PNM to provide testimony in this case?
That would have been late last year. I'm not certain of the exact timing. Last fall, I believe.
Okay. And just for the record, PNM's included about $150,000 in its rate case for your testimony. Does that sound right?
I saw that inclusion, yes.
Okay. So moving on, if you would turn to page 19 of your direct testimony, please. And here, the bottom of the page, you discussed PNM's decision to abandon the leases when they expired in 23 and 24. And you conclude that was a reasonable decision, right?
Yes, definitely.
Okay. Other than, and I think Mr. Herman covered some of this, but other than reading the past case documents, did you conduct an independent evaluation of whether PNM's decision to initially extend the leases in 2015 and 2016 was reasonable and prudent?
I didn't, I researched that case fairly extensively. And I'm familiar with the process.
So
it's my understanding that PNM pointed to an analysis that they conducted in the 2011 IRP related to extensions.
So in answer to my question, you did not conduct an independent evaluation?
Correct, I did not. Yes.
Okay.
Mr. Elliott, sorry, before you go on, just real quickly, you were just asking a question and you directed the witness to page 19, unless it's a different version of it. Is that the direct testimony of Joseph Miller? Because it's page 20 where he says, I conclude PNM acted appropriately in deciding to abandon the leases.
That is correct, Mr. Hearing Examiner. Thank you.
Just want the record to reflect that.
Yes, thank you. The Q&A starts on page 19.
And carries over.
Yes.
Okay, thank you.
Thank you. Turning to page 43, Mr. Miller, of your direct testimony. This is where you state recovery is warranted even though the assets will not be used in the future. In your opinion, is recovery warranted regardless whether or not the 2015 and 2016 Palo Verde lease extensions were prudent?
Well, that will ultimately be a decision for the commission. But as I said earlier, I'm aware of no findings of imprudence that impacted PNM's recovery of leasehold improvements. And so I would have thought that if there was a remedy that was going to be related to leasehold improvements, that it would have occurred in that case.
Let's turn to page 47 of your direct. And you reference the regulatory compact. Do you see, are you with me?
Yes.
Okay. In your opinion, does the regulatory compact require the company to make prudent investment decisions?
It's definitely an expectation in the regulatory compact that a utility makes prudent decisions.
Are you aware of any PNM investment decisions that you would deem imprudent?
In my research, I have none come to my mind, Mr. Elliott.
You include exhibits, certain testimony from prior cases of other PNM witnesses. And I'm just curious, how did you select those passages to include as exhibits?
I would say just based on research and their applicability to the issues of this case.
So I saw you had Mr. Phillips's testimony as JAM 2, and that addresses the decision to abandon the leases in 23 and 24, right?
Yes.
Okay. And you have Miss Eden's testimony as JAM 3, and that addresses contractual provisions that allowed the leases to be extended in 2015 and 2016. Is that right?
That is correct. Yes.
And Ms. Eden's testimony is JAM 4, and that addresses decommissioning, right?
Yes, that's correct.
And then JAM 5 is a page from the leveraged lease financing transaction. You see that one?
Yes.
Would you agree with me that none of these exhibits discuss or analyze whether the initial decision to extend the leases was prudent?
I'd have to read each of them in detail, but I don't believe they are addressing the lease extension decision. The original lease extension decision, I should say.
Okay, thank you. Let's turn to your rebuttal testimony now. And I think this is probably some area that Mr. Herman also covered a little bit. I'm looking at page 7, lines 8 through 9. And this is where you say that the leasehold improvements were prudently incurred costs for which shareholders have a reasonable expectation of a full return on their investment. What's the basis for that statement?
The leasehold improvements were prudently incurred costs, and shareholders have a reasonable expectation of full return. And so these leasehold improvements have been made over the 37, 38-year period of these leases. The leasehold improvements were required for the continued safe and reliable operation of Palo Verde. They were made on behalf of customers. And so I think, yeah, there is some reasonable expectation of a return on and of those investments by stockholders.
I'm sorry, I'm just getting a little feedback. But you didn't conduct an independent review of the decision to extend the leases, right?
You're talking about the initial decision?
Right.
Correct.
Okay. Well, let's assume that the lease extensions were prudent, but that the plant's no longer providing service to ratepayers. Is it fair to say that you do not believe the used and useful standard should be applied in this case?
I believe it should be applied in that the asset should no longer be in plant and service. But I do believe recovery of and on the investment is appropriate via regulatory asset.
Would you please turn to page 11 of your rebuttal? And at lines 15 through 19. Well, lines 15 through 17 specifically. You say Ms. Crane summarizes this section saying, therefore, the commission found that the company should continue to recover those costs from ratepayers during the period of the lease extension.
Yes.
And you quote from the commission's order on the following page, 12. And there the commission referenced the facts and circumstances of this case. But the commission didn't go on to address what might happen in the next rate case, did it?
Correct.
And would you agree that one of the factors considered by the commission in that order was that the least Palo Verde capacity was used and useful?
Yes.
Okay. I have no further questions. Thank you for your time, Mr. Miller.
Thank you.
Thank you, Mr. Elliott. Up next with Mr. Miller is New Energy Economy. Is that correct, Ms. Nanazi? And what do we have you down here for? Let me find the Excel spreadsheet. Is it 45 minutes? Is that right?
Yes, sir. Good morning.
Good morning, Ms.
Thank you.
Nanazi.
Okay, please proceed.
For the record, my name is Marielle Nanesi with New Energy Economy. Good morning, Mr. Miller.
Good morning.
So, Mr. Miller, how much are you being paid for your expert testimony in this case?
My company is being compensated $650 per hour for my work.
You would agree, would you not, that PNM had a substantial financial incentive to buy the 64.1 megawatts at Palo Verde? Because if PNM did not buy the beneficial interest in this capacity, there was some risk that PNM, not ratepayers, would bear the cost of the non-depreciated capital improvements and decommissioning expenses associated with the capacity after expiration of the leases.
I would say that I think PNM had the opportunity to acquire the 114 megawatts as well, but decided to do lease extensions on that. But could you ask your
But
question?
I'm asking you specifically about the 64 megawatts first, but we'll get to the 114 megawatts in a few minutes. You would agree that by PNM repurchasing the 64.1 megawatts at Palo Verde, there was a substantial financial incentive to buy it, because if PNM did not buy the beneficial interest in this capacity, there was some risk that PNM, not ratepayers, would bear the cost of undepreciated capital improvements and decommissioning expenses associated with the capacity after expiration of the leases.
I don't know that I would agree with that characterization. PNM also had significant risk of disallowance with that acquisition, which occurred. They were disallowed $80 million of that acquisition.
So you would disagree with that statement, is that right?
There is a level of incentive in terms of return for stockholders when a utility makes an investment, but I would disagree with that general characterization that you made.
Why?
There was potential benefit, potential risk to the company in an acquisition. Utilities are never guaranteed return when they make investments such as that. And that played out in that acquisition of those 64 megawatts.
Could you please turn to Exhibit C?
NEE Exhibit C.
Yes, sir. NEE Exhibit C.
I've got it open.
And this is the recommended decision and final order in case 1995, correct?
Yes, that's correct.
Could you please turn to PDF page 36 of 45?
I am there.
You're faster than me.
The Xeroxed page number is 19, but the PDF page number is 36, correct?
Yes, sir. That is
Okay, I'm there.
correct. Could you please read the paragraph 13 of that page?
Sure. It is the policy of the commission that PNM's ratepayers should not be responsible for decommissioning costs associated with Palo Verde Nuclear Generating Station Unit 1, associated with that portion of the life of such unit during which it is not owned or leased by PNM.
And now could you please turn in the same document to page 8, which is the final order. That was the recommended decision. And could you go to the final order of
What?
page 8? The same document, but what you just read was from the recommended decision. And then if you go to page 8, actually, no, I'm sorry. Let's start on page 7, which is just the introduction to what I want to ask you to read again. And on paragraph 25, it says,
Pardon me, you want me on page 7 of the PDF?
yes, please.
Okay, just one moment. Okay, I'm there.
Okay, great. Thank you. So on page 7, paragraph 25, it says the case described in paragraph 24 of the findings and conclusions should include, but not necessarily be limited to determining. And then could you please read what on the next page is paragraph B, C, and D?
First of all, I'm not certain of what it says the case described in paragraph 24. I'm not certain of what that case is, so I don't have context for what I'm about to read.
Okay, fair enough. Let's go back to paragraph 24.
Right, the paragraph 24 right above it, is that correct?
Correct. Do you want to read that into the record? That would be fine. You could read that out loud.
The entire paragraph?
Sure.
All other issues of rate-making treatment for the lease transactions and whether the commission's final order in case number 1804, which established inventorying, needs to be amended to reflect the approval of the lease transactions, should be determined in a separate case, which PNM shall file at least 120 days prior to the date that it needs to obtain a final order from the commission. The commission retains full authority over the facilities and over all issues of rate-making treatment for the lease payments, the lease costs of any gains or losses from the sale and leaseback concerning said facilities, including the authority to disallow any or all of the lease expenses and transaction costs on a used and useful basis, on the basis of imprudence in the cost of the facilities, or on any other lawful basis. Any approval of the lease transactions granted by this order is contingent on the commission's retention of such full authority.
And so now that you have that context, could you read on the next page, paragraph 25B, C, and D, please?
What responsibility, if any, ratepayers should bear for decommissioning costs associated with Palo Verde Unit 1 and related common facilities associated with that portion of the life of such unit during which it is not owned or leased by PNM? What share, if any, ratepayers should bear of the cost of decommissioning the lease transactions.
And could you read D as well?
What share, if any, of any gains or losses from the lease transaction should be borne by shareholders and ratepayers?
And now, can you please turn to, let me just ask you. You refer to P&M's actions or inactions regarding P&M's repurchase or lease extension as quote, flawed, unquote. Is that right?
First of all, which extension are you speaking of?
The 2015 and 2016 extension, lease repurchase and extension.
Okay, and what's your question specifically again, please?
You referred to that their actions or inactions as flawed. Is that correct?
In my testimony,
Correct.
was I referencing an order in that case?
No, I think that you were referencing, well, let's just go to both in your direct testimony on page 27. I think line 7, line 8, line 17, line 17.
Yes, yeah. Yeah, that sentence. Yes, its sentence states that while the commission concluded P&M's decision-making was flawed,
Right.
it concluded that, yes, right.
And then you also say that again on page 48 at line 8, you use that word flawed.
And I was referencing in both cases the conclusion reached by the commission.
But that's your characterization of P&M's actions, correct?
Not my characterization. I am referencing what the commission concluded in both of those cases.
It is a fact that the hearing examiner, the commission, and the New Mexico Supreme Court found P&M to be imprudent when it conducted no consideration of alternatives between the cost of the chosen generation resource and other available resources, correct?
I would disagree with your word no, evaluation of alternatives.
And is that because, go ahead.
My memory is that it was an insufficient evaluation of alternatives.
And is that based on the 2011 IRP?
I'm thinking about the order from that case and the testimonies. And I believe the commission's position was an insufficient evaluation of alternatives. Not that there were no evaluation of alternatives. That's my memory.
Okay, could you please look at New Energy Economy Exhibit 4? Have you seen this document before?
I have it open. Let me see. It's data response to a data request.
Correct. It was New Energy Economy's discovery to P&M in the 15261-UT case, which you understand to be the last litigated rate case, correct? And specifically that dealt with the Palo Verde assets, right?
I believe that was the last litigated rate case dealing with Palo Verde assets, correct?
You cite to case 15261 numerous times in your direct and your rebuttal testimony, right?
Yes, yes, correct.
Okay, could you look at the Q&A here? You also cite to Ms. Eden's testimony in as an exhibit in your direct, right?
I believe so. Yes.
Okay, and so New Energy Economy asked in question 1-4, please provide any and all strategist runs or any other economic modeling or financial analysis that demonstrates the cost effectiveness of the acquisition of 64 megawatts of Palo Verde 2 at the valuation indication in interrogatory number 3. If there are strategist runs pursuant to this interrogatory, please provide the GAF reports and NPV for each run. That's the question that we asked, right?
Mr. Hearing
Yes.
Examiner, I object. If I may state the basis, further elaborate. There's been no foundation laid for this discovery response with this witness or otherwise. It's also incomplete in terms of referencing other materials that were not provided. And we're not here to relitigate the issue of Palo Verde prudence with respect to the 64 megawatts or the 114 megawatt lease extension.
Ms. Nnazi?
I believe that this comes in as pursuant to Rule 801D2. This is a statement by a party opponent, and it's absolutely relevant to Mr. Miller's testimony, given the fact that he says that that PNM's position in this case relative to the 64 megawatts and the 114 megawatts was flawed. And what I want to get out is this statement here, which says PNM has not performed any strategist runs, economic modeling, or financial analysis with respect to the acquisition of the interest in Palo Verde 2 at the valuation cited. I think it's pretty critical information, and it's made by a party opponent.
Objection overruled.
So, sir, could you?
Objection. Okay, sorry, go ahead, sir. Sorry, pardon me.
Sir, could you please read the first sentence in the paragraph 3 under response objection?
Okay, and I believe I believe this question is whether or not PNM performs strategist runs ahead of that decision to extend, right? Not after the decision to extend.
Correct.
Okay. Okay, that paragraph reads, PNM has not performed any strategist runs, economic modeling, or financial analysis with respect to the acquisition of the interest in Palo Verde 2 at the valuation cited.
Thank you.
What valuation was cited here? Or was
For the purpose of this question, it's irrelevant.
It mentions a valuation cited in interrogatory number 3.
Correct.
Just don't know what that is. Okay.
Could you please turn to New Energy Economy Exhibit 5?
And while he's doing that, Ms. Nanasia, NPV is net present value. GAF is
GAF reports. Those are the actual strategist outputs.
okay. Does the abbreviation GAF stand for something specific?
It might, but I don't remember what it is at this moment, but I could look it up and then get that to you. And sir, I noted that you said that did you read any of the transcripts in the 15-261 case?
I think I remember reading parts of some of those transcripts. Yes.
And did you read Vice President, P&M Vice President Chris Olson testimony in that case?
Is that what I have open now in
Yes,
Exhibit
sir.
5? So
And
this
can-
is not the actual transcript, is that correct?
No, this is the actual transcript of Mr. Olson from.
What I have is
Oh,
8 pages long. Is that the same document?
This is part of the actual transcript. Yes, sir.
Okay,
Yes,
we're-
I just
we're
don't-
really- We're doing really well this morning. We're starting to get a little choppy, stepping over each other.
Oh, I
So,
see. I do see 1 page of Q&A. Okay, I didn't see any Q&A. I see it now.
If you
I'm
could,
not, I don't believe
Oh,
I've read
oh.
this before. To answer your prior question. I just wanted to review the document before I answered that. And I don't believe that I've reviewed this.
so while you read some of the transcript from 15261, you did not read Mr. Olson's testimony. Is that what you're saying?
I may have read portions of his testimony. I don't recall ever seeing this transcript before.
So page 7 of 8 on the PDF.
Yes.
I asked Mr. Olson about that same interrogatory question that you just read into the record. And if you look at lines 8 through 12, I repeated what we just discussed at New Energy
Yep.
Economy Exhibit 4. Is that right? Do you recognize that?
Yeah, just let me read that real quickly.
Please.
Yes. Okay.
And then on line 18, he read the answer that you read into the record that I just asked. Is that correct?
Mr. Hearing Examiner, same objection. And I think if I may further elaborate, this explains a technique that Ms. Nanasi has used on a number of occasions where she has a witness read a specific highlighted response to discovery without including the entire discovery response or other documents, and then characterizes it as, well, this is what the witness testified to, when in actuality, all it is the witness reading a select portion of what Ms. Nanasi has identified for the witness to read. And again, there's no foundation laid for this testimony. It's also cumulative of just what we just covered.
Mr. Nazi?
It is definitely cumulative because it is, one was the interrogatory, and this is now the actual transcript from which I wanted to perfect the fact that it wasn't just taken out of context. The P&M has known about this. They could have put in anything from Mr. Olson or whomever they wanted to rebut it. But the fact is that this was critical to the decision by the hearing examiner, by the commission, and by the Supreme Court. They all cite to this very question. It's in the law that found imprudence, and part of it was based on this. And so I think it's important when you and the commission are making their decision about if ratepayers should pay for undepreciated investments or future decommissioning costs, to know that Vice President Olson said, we didn't do any financial analysis before we repurchased and extended the leases. To me, it appears that this is absolutely relevant evidence. Again, under 801D2, it's important. And all I wanted was Mr. Miller to confirm that there was an interrogatory, and then there's this transcript.
Ms. Nazi, when I have my hand up, that means stop, please.
I'm sorry, I wasn't even.
That's fine.
I apologize. I didn't even see you.
That's fine. Objection overruled under the commission's relaxed evidentiary standards and mission to get at the truth of relevant issues in this organic rate case proceeding, which is not a bilateral civil litigation proceeding. Please proceed and answer. Do you want to re-ask the question?
Yes, thank you, sir. So you saw the same language from that interrogatory in this transcript, did you not, sir?
I would first say that I believe what I'm reading is only referencing the 64 megawatt acquisition for unit 2. I haven't read anything yet that is speaking about the unit 1 and 2 lease extensions. But what I am reading is saying there was a lack of analysis prior to acquiring the 64 megawatts on unit 2.
And that's your understanding, is that right?
In this quick read, that is my understanding. And the company received an $80 million disallowance for that acquisition.
PNM sold its 114 megawatts to what entity?
PNM did not own the 114 megawatts. The lessors owned the 114 megawatts per the original sale and leaseback arrangement.
And who was that 114 megawatts sold to?
The 114 megawatts ultimately, I believe, was sold to Salt River Project.
At what cost?
I am not certain of that cost.
Well, sir, you, in your testimony, I believe at page, let me, can I have one moment, sir? I'm sorry.
Yes.
Page 29 of your direct.
I'm there.
On line 11, you're asking for ratepayers to pay the difference in proceeds from the sale of the 114 megawatts to Salt River Project between the sale cost and the actual book value, right?
So this $0.3 million is the sale of the common facilities that PNM did actually own. So not the 114 megawatts of unit 1 and 2 specifically, but the common facilities, the portion of the switch yard, transmission, and some other assets.
But you don't know how much the 114 megawatts were sold.
Okay, for the common facilities, I believe that is spelled out in either witness Sanders or witness Heffington's testimonies. I can't recall that sale amount. I know they were attempting to sell it at the book value, And in the end, there ended up being a delta between the price paid and what was on the books. And that's what's represented in that 300,000 there.
When PNM sold its 114 megawatts to Salt River Project, it did not include the cost of decommissioning, future decommissioning costs, right?
Going to object, that mischaracterizes his testimony and the facts.
When the 114 megawatts were sold to Salt River Project, it did not include the cost of decommissioning, future decommissioning.
Are you asking when the owners of the unit 1 and 2, 114 megawatts sold that to Salt River Project?
Yes, sir.
Could you ask that one more time to make sure I answer properly?
It did not include the cost, future cost for decommissioning.
It's my understanding that the Salt River Project will be paying for the decommissioning or spent fuel storage associated with the fuel consumed under their ownership. I also believe they are paying for the decommissioning associated with capital upgrades that occur under their ownership.
Does Salt River Project have to pay for future capital expenditures?
They do. Or, well, I don't know the terms of that sale, I should say. PNM does not have to pay for future capital investments or capital upgrades following the end of the lease.
What do you mean following the end of the lease? When are you talking about?
Yeah, so the unit 1 lease expired in January of this year. I believe the unit 1 leases expired in January of this year, and I believe the unit 1 lease expires at the end of next year. And following that point in time, PNM will not be responsible for paying for capital upgrades on that interest in Palo Verde. I don't know, I would assume SRP, they now own those assets. I would imagine they're going to have to pay for the capital upgrades associated with their portion of Palo Verde. Not unlike the other owners.
Can you please turn to Exhibit A?
NEE Exhibit A?
Yes, sir. And this is the, you refer to the Diablo Canyon decision in your testimony, is that right?
I do, yes.
And that was settlement, correct?
Check quickly. Yes, that was a settlement.
This is the Diablo case that you referred to for precedent on matters at issue here with Palo Verde. Is that right?
Correct.
Could you please turn to PDF page 43 of 78? No, actually, it's PDF page 44 of 78, but on the bottom, it's page 43 of the decision in the Diablo Canyon case.
Sorry, did you say 48 on the PDF?
44.
4. Okay, I'm there.
And in the middle of the page, you understand that that PG&E in that case asked for $52 million, but only received rate recovery for 18.6 million. Is that right?
That's correct. Yes.
And the decision explained the basis for that number, correct?
Yes.
And it says here that in the middle or the end of the page where there's an indentation, it says here, in approaching settlement on this issue, the settling parties desired to identify a set of principles upon which to base that settlement. Did I read that correctly?
Yes.
Could you read the first principle that the California PUC articulated for the settlement of the Diablo Canyon nuclear case that you refer to in your testimony? The first principle?
Yeah. It starts with one principle.
Yes, please.
One principle was that PG&E should recover its direct costs incurred during the time that the project was reasonably and prudent undertaken. And that project specifically is the project seeking a 20-year operating license extension.
And then the other principle that the PUC adopted and articulated was found on the next page. And the first full sentence, could you read that, please, sir?
The one that starts with the parties opposing?
The settling parties, the continuation of that. This is the second principle.
I'm with you. The settling parties then agreed that PG&E should not recover the direct costs incurred subsequent to that deferral request. And so what this is, if I could, this is speaking to the fact that PG&E was seeking a 20-year operating license extension. And in 2011, they asked the NRC to defer issuance of that operating license. Yet they continued spending money seeking the operating license extension. And so it's my understanding that the commission agreed with a settlement that said the costs you incurred prior to asking the NRC to defer issuance of that license is appropriate, but not those costs afterwards. That's my understanding of this issue here.
That's exactly correct.
Okay.
Could you please, this case also that you referred us to in your testimony addresses how the plant should be depreciated. Is that right?
There were remaining costs that were unrecovered that were addressed as part of this order.
And so that is on page 47 PDF, page 47 of 78. Could you read into the record, please, sir? Could you please read the first paragraph? You don't have to put in all the citations, but just under the 3.6 proposed rate making and cost allocation issues. So you can omit the citations that are in here, but could you read that as well?
Wait, I don't see the 3.6 that you referenced.
It's on, are you on page 47
I
of
am
78?
at the bottom of it.
No, at the bottom of the page, it's page 46, but it's PDF page 47.
Okay.
You see that title?
Oh, yes, I'm sorry. There's a one number difference between the two. I am now on PDF number 47. Yes.
Thank you.
Okay.
Could you just read that first paragraph, but you can omit the citations, but other than that, could you just please read the first paragraph about how the rate making would happen as a result of this settlement?
The paragraph that begins with PG&E's proposed rate making treatment.
Yes, sir.
Okay. PG&E's proposed rate making treatment for Diablo Canyon as it approaches
Sorry,
retirement.
sir, could you slow down a little bit? PG&E's.
Yes, sorry about that. PG&E's proposed rate making treatment for Diablo Canyon as it approaches retirement does not alter the existing rate making treatment, which has generation rates based on a depreciation schedule that assumes Diablo Canyon will be retired and depreciated to zero at the end of 2024 for Unit 1 and at the end of 2025 for Unit 2. PG&E does propose to add an annual true-up to reflect actual depreciation and capital spending at Diablo Canyon.
So what you understand, sir, is that it was required as a result of this case that you cited to align the useful life of Diablo Canyon with the depreciation of that asset. Is that correct?
You know, this case addresses remaining investments at Diablo Canyon prior to what was expected to be the end of its operating license. Things changed in the fall of last year when California legislature required them to extend operations 5 years. So it looked like they were going to be fortunate and the actual service life was going to match with the depreciation life. But in the end, that's not occurring, and that is very difficult to match that exactly with all the changes taking place in the energy industry.
You understand that the reason that that PNM that PNM didn't repurchase the 114 megawatts was because they couldn't prove that it was cost effective compared to solar and storage, right?
They conducted thorough analysis and identified there were alternatives that were cheaper for customers and pursued those.
Can you please, you also refer in your testimony to the settlement in the San Onofre retirement case, is that right?
I do.
And could you please now turn to Exhibit B, if you would.
I am there.
And could you please go to page 4? This is the San Onofre case, correct? This is the decision that you were referring to, correct?
Yes, the commission approval of the settlement related to San Onofre. Yes, correct.
And this decision approves as a settlement agreement between Southern California Edison and San Diego Gas and Electric Company, collectively referred to as the utilities, and 4 other settling parties, which provides resolution of rate recovery issues related to the premature shutdown of the San Onofre generating station. Is that correct?
That is correct.
And this was following a steam generator tube leak on January 31st, 2012, correct?
It's my memory of reading this case that there were hundreds of tube leaks.
About
Okay.
1 minute, Ms. Nanazi, I'm sorry.
Yes, me too.
The steam
So,
generator replacement caused the demise of that plant. Yes.
okay, and could you read on page 4, under the summary of the decision, could you read, please, the second, third, and fourth paragraph, beginning with the primary, and make sure you read it slowly, please.
PDF page 4.
Yes, sir, where it starts with the primary.
That's PDF page 5. I think.
Is that correct, Ms. Nanasi?
I think it's page 4.
My page 4 has just bullets and a
Yeah, I think it.
table of contents completion.
Yeah, I think it's
Right.
fine.
Yeah.
The primary result of the settlement is ratepayer refunds and credits of approximately 145 billion. The utilities must also stop further collection of the steam generator replacement project costs and rates, return all steam generator replacement project costs collected after January 12 to ratepayers, and accept a substantially lower return on other prematurely retired SONGS assets. So the bottom line is they broke this nuclear plant and still were allowed recovery of the investment and took a haircut on the return on equity portion of the investment. The commission disallowed recovery of the project that caused the demise of that plant.
And
By taking a haircut, what was the recovery allowed?
Mr. Hearing Examiner, my memory is that the ROE portion went down to 3%.
Okay. So all right. Thank you.
Yes.
my time is up with you. Unfortunately, I had lots more questions, but thank you so much for your testimony, Mr. Miller. And Mr. Hearing Examiner, I asked to move New Energy Economy 4 and 5 into the record. And that's it.
Thank you, Mr. Nasi. New Energy Economy 4 and 5, Mr. Alvidrez, and parties.
Yes, we maintain our objection to those.
Let's take our 15-minute break. I'll rule on those after the morning break. Right now it's 10:31. Let's come back at 10:47. 10:47. We'll start up again. Thank you. We're in recess.
listen to quotes from here on out.
Yeah. Mr. Ryan, is 801D2 with a small d?
MRA 801D2. I'm going to say yes, a
All right.
lowercase d. But I will find out right now.
Judge, we can't hear you.
Mr. Lee, that I was incorrect. D 11801 D2 is a capital D.
It's in parens, correct?
Yes, for citation purposes, that's what you would do.
I think my mic's on now, correct?
Yes,
Yes.
Judge.
All right. Good morning. We're back from our morning break. We're ruling on the objections to NEE exhibits 4 and 5. The commission understands the background and the issues on the ruling of prudence at issue in those cases and the Supreme Court's ruling and the aftermath of that. To the extent that the documents may have taken out of context, that concern has arisen before. And Ms. Nanazi, I hope that that practice or penchant will be curtailed. Nevertheless, the exhibits are admitted for whatever value they are worth to the case. So NEE exhibits 4 and 5 are admitted. Now, let's move on. To the next cross-examination. Do we have any more cross-examination?
I believe
of
staff,
Mr.
but
Miller?
Mr. Maderos, real quickly with Mr. Alvidrez. Sir,
I'll get right.
oh, you'll get there. Got you. Okay.
Yeah, I just wanted to see where we are because I'm trying to find my matrix.
I think
On
staff, Mr. Borman has 10.
Okay. Now,
that right?
Mr. Alvidrez, yes. Mr. Alvidrez, this is a different issue. It's regarding Mr. Sanders and Gray coming back to testify.
Yes,
Would
sir.
they be available Friday morning, first thing, back to back?
I had thought it was just going to be Mr. Sanders. But,
Well, it turns out it's going to be both if you have them
Okay.
both available.
I will check. So Friday morning, they would be first up. Is that the thought?
Ideally, yes, sir.
Okay. I will check on their availability this week and get back to you after lunch.
Thank you, sir.
Thank you.
Okay. Mr. Borman, you have 10 minutes, is that right?
10 minutes is what I reserved, Mr. Hearing Examiner. I don't think I'll use it all.
Okay, thank you. Please proceed.
Thank you and good morning, Mr. Miller.
Morning, Mr. Gorman.
Would you agree that the decision as to whether create a regulatory asset in this proceeding is within the discretion of the commission?
I do.
Okay. And I think you stated in response to questions from Mr. Herman of the Water Utility Authority that a utility is not guaranteed recovery of what you termed remaining assets. Is that correct?
Correct.
And by remaining assets, what exactly did you mean?
Such as these leasehold improvements that have not been fully depreciated,
So sometimes they're called stranded assets.
sometimes called stranded assets. Yes.
Okay. And whether or not any regulatory asset created by the commission in this case is authorized to earn a rate of return on the asset, that is also within the discretion of the commission, is it not?
Absolutely.
Okay. Now, can you turn to page 7 of your rebuttal? You there?
I am there. Yes.
Okay. Now, beginning on line 7, you state that customers have enjoyed years of low-cost, reliable service associated with the PV NGS leases. Do you see that?
I do.
Can you show me where in your testimony you perform the analysis that supports this statement?
The energy from nuclear power has been relatively expensive compared to other forms. And, but no, I did not perform the analysis that you're mentioning.
Okay. And can you show me where any P&M witness in this proceeding provides the analysis that would support that statement?
I'm not aware of any.
Okay, thank you. Thank you, Mr. Miller. I have no further questions. Thank you, Mr. Hearing Examiner.
Thank you, Mr. Foreman. Do see the participant list. We have Commissioner Ellison on. Commissioner Ellison, do you have any questions for Mr. Miller?
Yes, please. I would like to ask a few questions. Hi, good morning, Mr. Miller.
Good morning, Commissioner Ellison.
I would like to ask a few questions about this, the Palo Verde issues. You just mentioned to Mr. Borman that you did not do an economic analysis in your testimony. Do you recall, what would be essentially the levelized cost of the power from the 114 megawatts of Palo Verde capacity that was abandoned?
Are you referring to if it had been reacquired at market price? What would the cost of that power have been?
Yes, essentially, if the lease had been, I'm not sure if the lease would have been renewed or if that capacity would have been purchased, but what essentially the levelized cost of power would have been.
And it's my understanding when they had the first lease extension opportunity in 15 and 16, that was an option in the sale and leaseback agreement. But here, when they needed to make the decision in 2020, the option was to reacquire at market price and not to extend the lease. But, I spent quite a bit of time with the head of IRP, Nick Phillips, and understanding his analysis in the abandonment analysis and the decision to move away from the Palo Verde 1 and 2. I'm not certain if he broke that down per megawatt hour. Obviously, I remember the calculation of the present value of revenue requirement for customers for options, but I don't think I saw that on a per megawatt hour basis or per megawatt basis for that matter. But the replacement resources were quite a bit cheaper, and due to the advancements and decline of alternative sources of power.
And that analysis that you speak of, is that performed in 2183, the case 2183?
I'm not good on numbers. I think that's it. I refer to that as the abandonment case, but yes, that analysis is in there. Company witness Phillips.
Okay.
Also
And
witnesses.
And you do have a couple of charts in your testimony with the declining costs of solar and wind power. However, these are obviously variable generating sources, whereas the Palo Verde is a base load. So it is somewhat a apples and oranges comparison, isn't it? If you just look at the cost per megawatt hour.
Yeah, levelized cost of energy. When I utilize that, I usually just stick with one technology. I don't like when they mix levelized cost of energy and have multiple technologies. But yes, in PNM's analysis, not only did they look at the cost of other alternatives, such as wind and solar and battery, they also were extremely thorough in ensuring the resource adequacy of those new resources, and spent quite a bit of time and effort ensuring that the lights would stay on if PNM moved away from a nuclear plant and went to, in this case, solar and batteries. And so a lot of time and effort went into that. So it's not just about the cost, it's about the reliability.
I understand. So what you're saying is that the Palo Verde capacity was quite expensive, and that the modeling showed that it could be replaced with a combination of solar and batteries to achieve a similar level of reliability. Is that correct?
Yes, based on recent cost reductions, and also batteries have been important. Batteries historically have been relatively expensive. The price has come down, but batteries have not been ready for prime time until recently in terms of being available on a meaningful scale and being reliable enough.
So why is it that PNM chose to repurchase the 64 megawatts of leased interests, and then chose to abandon the 114 megawatt leasehold?
So the decision to reacquire the 64 megawatts of Unit 2, that decision, per the sale and leaseback arrangement, it's my understanding, needed to be made in the 2012 and 13 timeframe. And so if you would look at page 23 of my direct, you can see the relative pricing of solar at that time compared to what it was in the 2020 timeframe when it made the decision to abandon the 114 megawatt leases for units 1 and 2. Significant reduction in cost for solar over that period of time. Solar can't replace nuclear power, so the batteries were necessary. They've made significant advancements since that point in time as well. You could never have done this back in 2012.
Right. I understand. I would like to know that levelized cost of the Palo Verde. However, I think I have a good sense of the solar and wind costs, and perhaps the battery, but not the Palo Verde. So if that's completely contained in that previous case, I'm fine with it. But if not, I would like that information.
Okay. And one challenge with levelized cost of energy is it really doesn't consider the capacity value. And I'm sure you're aware
Right.
of that. I just wanted to mention that.
I understand.
Mhm.
I understand that. Okay. I think that's all the questions I have, Mr. Medeiros.
Thank you, Commissioner Ellison.
Thank you.
I don't think, hearing examiner Ryan, I don't see our other Commissioner Aguilera.
No,
on
I
the
don't see him
participant
as
list.
no,
Okay. Do you have questions for Mr. Miller?
a few, yes. Mr. Miller, how are you?
I am well, thank you.
From what I discern from the testimony in this case and the questioning that you've received so far from the interveners, is that there seems to be a sort of open question that seems to demand an answer, which, and if you think I've misunderstood, then you can correct me, but effectively, PNM goes ahead without analysis and renews some of the leases, and that determination is deemed to be imprudent. And then the interveners say, so therefore, as you're making these investments in capital improvements as required under those leases, you're effectively doing something that was imprudently done. And why in the world should ratepayers be on the hook for that? That seems to be their point. And so maybe if you have a perspective on that, you can explain to me what is the most persuasive response to that assertion.
Sure. It's my understanding that the result of the 2015 rate case, the commission had concern that PNM had not done sufficient analysis of alternatives, a robust analysis prior to making the decision to acquire the 64 megawatts on unit 2 or the lease extensions on units 1 and 2. My review of that case is that there was some analysis of extending the leases versus what I believe was at the time acquiring that amount of combined cycle capacity, that was done in the 2011 IRP. And so that was not sufficient for the commission, and I understand that. But the issues related to the extension of the leases, in my opinion, were addressed in 2015 rate case. And I say that primarily because they were even appealed to the Supreme Court. New Energy Economy appealed the fact that the commission was going to allow PNM to pass on those lease expenses for units 1 and 2 onto ratepayers. They took that to the Supreme Court. The Supreme Court agreed with the commission that that was appropriate. And so, it's, I believe I've not seen any issues of imprudence that impacted the leasehold improvements that we're talking about today. The fact that now it makes sense to abandon those leasehold those unit 1 and 2 leases. What has allowed that to happen has been the steep decline in the price of alternative forms of power production. And not just the price, but in particular batteries, to be able to replace nuclear power. As you know, nuclear power can be generated when the sun doesn't shine and the wind doesn't blow. And so it's solar with batteries that allows that replacement. And that just would not have been viable back in that 2011 and 12 timeframe.
Okay, and just so I understand, and just to make sure I've understood your answer correctly. I mean, I understand it's nuanced and going back into the case history, which we will do eventually. I mean, with a fine tooth comb and piece all that together. But if I understand what you're saying is that the fact that the commission and then which on a decision which was affirmed later determined that renewing the leases was imprudent. I mean, I guess I still just don't understand how logically then we can come to the conclusion that the capital investments necessary were a worthwhile expenditure. I mean, if it seems just logically impossible to say an event for which I gave no thought, the consequences of that event are thus necessarily passed along.
So I would mention that these leasehold improvements have been a requirement for PNM from day one when they entered into the Arizona Nuclear Power Plant Participation Agreement. They were on the hook to pay their portion of these leasehold, or pardon me, of capital improvements. The sale and lease back, the financing companies only took responsible for the initial investment. PNM has always been responsible for the capital upgrade. So this remaining balance of leasehold improvements that's at issue here, those leasehold improvements have been made over the course of what is now 37 to 38 years for those unit 1 and 2 interests. And so those leasehold improvements were made while the units were in service to customers and were used and useful. And so it's not unlike if PNM owned this percentage of Palo Verde over time, it's really not different than that. And so those investments were necessary for customers to get the benefit for 37 to 38 years for those leases. And I think it's very appropriate for recovery of and on those investments. And I would also mention that PNM has not made money on the initial construction costs associated with that 114 megawatt interest. And so they did the sale and lease back, and that was extremely beneficial for customers. And so they did not earn on that investment. It was more cost effective for companies that had the tax appetite to own that, to get the benefits of the investment tax credit and also the accelerated depreciation. And
It's another problem that seems, and I appreciate that. I believe, if I understand the Water Utility Authority's position on this subject, just saying something was used by ratepayers itself doesn't necessarily dictate that like sort of cost recovery questions, right? Because if you commence from a position where doing something was imprudent, then the ratepayers are committed to it either way. I mean, you sort of start down the road and then you say in midstream, like, well, it might have been the wrong road, but we're here anyway. So used and useful. Is that just a gross overgeneralization of what they're arguing, you think?
I don't believe, like I mentioned earlier, when I hear used and useful, it has to do whether or not an asset should be in planned service.
Okay.
When it's no longer used and useful, that asset needs to be expensed or it needs to be moved to a regulatory asset for recovery. And in the vast majority of abandonment and retirement cases that I've evaluated across the industry, recovery of and on is typical. Sometimes there will be a haircut on the return on equity. Sometimes there might be just a debt only return on the investment. But
sometimes there might be a complete disallowance though, too, Mr. Gray. It's not out of the ordinary for there to be complete disallowance.
I'm sure Mr. Medeiros meant Mr. Miller. We were just talking about Mr. Gray. So just for the record purposes.
Yeah, I'm
Mr. Miller.
In my research, I'm not sure I saw a case where there was a complete disallowance. I would also point you to Witness Graves' rebuttal exhibit, where he reviewed 38 power plants and their ultimate treatment of stranded investment. In the vast majority of those, there was full recovery of and on. There were a couple with debt only. No, I did not come across one of those. I'm not saying it's not out there, but I didn't come across one.
Pardon me, Mr. Miller, for misstating your name. Go ahead, your Examiner Ryan.
So next question I have is at your direct testimony at 34, you talk about the standards for when it's appropriate to establish a regulatory asset. And at that bottom there, 18 to 21, the criteria for a utility to establish such an asset is whether it is likely that recovery will be allowed by regulators. And I was thinking about that and that sort of formulation of the standard, and that sounded pretty strange to me, because effectively what you're saying is whether someone's going to be a regulatory asset, at least in this context, is going to be whether the commission will allow recovery.
That's right.
And then we come to the proceedings, and we're here to discuss whether it should be allowed. But on some level, it seems like just to be a regulatory asset, you have to determine that it will be allowed. Yeah. My concern when I read it was like, well, doesn't that just sort of create a sort of tautology? I mean, then necessarily, therefore, it must be allowed, because if it is a regulatory asset, then it is allowed. I don't fully follow.
Yeah, so I've over the past 10 to 15 years, I've worked on a number of power plant retirement evaluations in the ultimate recovery treatment. And yes, once the asset is retired or abandoned, it needs to be expensed or moved to a regulatory asset. And so the accounting standards are, if you have reasonable assurance of recovery of that remaining investment, then you don't have to expense it. That assurance goes up if a commission grants you the ability to create a regulatory asset. That doesn't say that the commission is yet allowing you to recover that regulatory asset. And so that's what's happening in this case. PNM was granted the ability to create a regulatory asset and not expense those. And now this proceeding is determining whether how much recovery of and on is appropriate. If that helps.
Sure. No, I think I do understand the point there. I don't know if I fully comprehend it, but I understand what you've just said to me. So at 36, yeah, go ahead.
I was just going to say it can no longer be on the balance. It can no longer be on the balance sheet unless it gets moved to a regulatory asset. Otherwise, it's got to be expensed.
Okay. Over from 35 to 36, you indicate that no one could have anticipated the transformation of utility generation portfolios. And I guess I would just challenge that a little bit. I mean, is that really the case? I think there was a fair bit of, if I remember going back and reading the history of these proceedings and all the issues around Palo Verde, I mean, new energy economies issues back way when was, well, there's a transition to renewable resources afoot, and you're getting us stuck in this nuclear facility that's super expensive, and that's really not a good idea. I mean, that's been their argument all along. And so I just want to ask whether you would soften your position here about people not predicting this transition.
For the last 15 years, I've been very involved in generation planning and making retirement decisions for power plants, trying to estimate when they actually will retire. And it has been extremely challenging with all that has been changing in the energy industry and landscape, with fuel prices changing, with regulations and legislation occurring, actual regulation, threats of regulation, and most importantly is the advancement of renewable resources, solar and wind, and most recently batteries. And batteries, not just in price, but in their ability to truly provide some capacity value. And so it's been extremely challenging to make decisions, appropriate decisions with information that exists. And so what you do is you try to use the best assumptions, stress those assumptions in your analysis, and make decisions and adjust as you move forward. But it has been extremely challenging. I think it has been absolutely appropriate that PNM has been depreciating those assets over the new operating life. That's entirely common for nuclear plants. And when it became cheaper for customers to do something else, they are doing that. It's my understanding that in the 2017 IRP, there was some evaluation of continuation of that 114 megawatts. And at that time, it was inconclusive. But when they did it in 2020, based on actual RFP responses for solar and batteries, it made sense to change. And they did that. And I don't think should be penalized for making that decision on behalf of customers.
All right, just last question I'll ask you is just to make sure I understand, prior to the break, New Energy Economy and Ms. Nanasi, they asked for the admission of some documents from other cases which established, which are directed at what inquiry the company made at a point in time when it was necessary to evaluate costs associated with moving forward with the leasehold improvements, well, not the leasehold improvements, whether or not to move forward with the Palo Verde leases at all, is my understanding. And
I think that was move forward to acquire the 64 megawatts. And what I briefly saw there, it was not regarding lease extensions. It just said an evaluation was not done prior to acquiring the 64 megawatts, and that led to the $80 million disallowance for the Unit 2 acquisition.
All right, well, I guess what the question I'm just trying to get to is whether the leasehold improvements were prudently incurred, well, the cost for those leasehold improvements were prudently incurred. It's a separate and distinct question from whether or not the company should have continued. And again, I know this is very nuanced because it takes us back into the history of this entire episode, but that's a different matter than whether PNM should have continued operations at the plant or should have continued utilizing the Palo Verde. I suppose is that a fair statement?
The leasehold improvements have been made over the 37 to 38 year service life of those interests to customers. And the leasehold improvements were a requirement, have always been a requirement for day one for PNM to make those. They were necessary for customers to get the benefit of these two units. They were necessary for Palo Verde units 1 and 2 to be reliable and safe. And so there has been, what I have seen, a robust process of prioritizing those projects amongst the co-owners. And I've managed 2 plants that were owned by multiple utilities. The process they utilized to make those capital upgrade decisions is very consistent with what I'm used to. And so I think the leasehold improvements have been appropriate.
Okay, thank you, Mr. Miller.
Mr. Miller, I want to go back to your testimony. And again, apologies for misstating your name. But
thank you.
You said in the vast majority of abandonment and retirement cases that you've evaluated across the industry, recovery of and on is typical. Now, we're addressing the imprudence determination and on the Palo Verde leases, right?
Could you ask that again, please?
In your testimony.
In my oral testimony?
Just now, I'm reading from the real-time transcript.
Okay, all right.
And you talk about the vast majority of abandonment and retirement cases that you have evaluated across the industry, recovery of and on is typical. Now that's abandonment and retirement cases. We're evaluating a prudence issue, right?
Not in my opinion.
No?
No, I have not seen any imprudence finding that has impacted recovery of leasehold improvements.
Okay, so are you aware of any instances in which any recovery has been disallowed for findings of imprudence?
I have.
Okay, so I'll be clear that apparently we were talking about two different issues. You're saying
Power plants.
power plants in general, not
Yeah.
improvements, right?
Well, the improvements are included in the stranded cost in many plants that retire. You know, you've got still a little bit of the initial investment in there, and then the capital upgrades that have taken place over the life of that plant. Not unlike the leasehold, or pardon me, the.
So when we're focusing on attempting to develop a remedy, if any, for findings of imprudence, or you wouldn't disagree that you talk about a haircut. The haircut you see is usually, what did you say for the haircut that you usually see in that context?
Recovery of the investment is very, very common. Occasionally, you will see a haircut on the return on the investment. So sometimes instead of the normal WACC that a utility has, you might see a haircut in terms of maybe moving down to just debt only. But I will say that in the majority of cases, it's full recovery of and on. In the Graves testimony, it's probably the most thorough listing of treatments of power plants.
Right. But you said you looked at the 2015 rate case here, 15261, right?
Say that again.
You say that you looked at are you having trouble hearing me?
No, I didn't. Just
Okay.
then, not normally.
The
Yes,
2015 rate case, 15261 UT, right?
Yes.
There was a full disallowance except for some O&M costs in that case with regard to the balanced draft, wasn't there, by the commission?
Is this regarding San Juan or Four Corners?
San Juan.
Yeah, I'm familiar with that case, but that's not been a focus of mine and not been a part of my testimony. But yes, I'm aware of some disallowance associated with that.
About 52.3 million.
Is that related to the SCRs?
At the balanced draft system.
Oh, balance draft, pardon me. Yes, I'm minimally familiar with that.
All that was allowed in that case was approximately $300,000 per year, which is about the amount of the O&M savings.
I see.
That there for finding of imprudence, right?
I'm not familiar with the details. Generally, I believe the imprudence was related to.
Well, we could, that's fine. We could check the final order at page 52 of that case to determine what the actual remedy was for the finding of imprudence in that case. And then the Washington Commission also found back in a 2016 case. Did you review the Washington Commission's opinion in Pacific Power and Light?
Was it related to a certain power plant?
There was the SCRs in the SCR expenditures on a power plant there, on a coal plant, not a nuclear plant.
Yeah,
but that was more in line with what you were saying. That was a denial of a return. They allowed a return of, but not a return on. So that was the kind of haircut that would be within the type of length of haircut that you were referring to, right? Not a full shaving.
You know, based on my review of this case, I believe that full recovery of and on the remaining leasehold improvements is appropriate. I strongly believe that. I do understand, based on balancing of interests from customers and investors, that it may be appropriate for some haircut. I would think nothing less than at least debt only on the full amount, but I guess that's what I would say, if that helps.
Were you observing our discussion with Mr. Graves
I
when he testified?
I saw bits and pieces of it. A lot of it was on, I believe, San Juan and Four Corners, so it was not necessarily applicable to me, but I'm very interested in that subject. I've done a lot of environmental compliance planning during that very challenging period. And so I'm drawn to those subjects. It was a very challenging period of time.
It was. Okay. Hearing Examiner Ryan, anything further?
I just want to make sure I understand. And without my immediate command of having the RD and the final order and the previous cases right at my fingertips, I mean, I'm at sort of a disadvantage there, but you know, it's my understanding effectively that the commission found there was imprudence in moving forward with the plant at that time. And again, I know that's subject to qualification. What does that mean? The sale and lease back, and it's just too complicated. But in any case, you know, hearing you, there's something that I just want to know, which is to say, merely because the plant was used does not make it prudent, right?
Oh, I agree.
Okay.
Oh, absolutely.
All right. So if there's some reason to conclude moving forward with the plant was not a good decision on behalf of PNM, I mean, and there was a finding of imprudence, I mean, there has to be some penalty paid. I mean, otherwise it's sort of, you know, I don't know, the whole system sort of falls apart.
They got an $80 million hit for their acquisition of Unit 2, and that is significant. You know, the
$80 million hit attributable to what?
And what that's based on is, it's my understanding that their acquisition was at $2,550 per kW, and that they were allowed a little bit over $1,300 per kW. When I do the math on that with 64,000 kilowatts, I got 80 million. I'm hoping that's right. That's very significant. The Unit 1 and 2 lease extensions per the sale and leaseback agreement, if they wanted to extend those, they would be at half of the original lease expense. There was some level of analysis done in the 2011 IRP on that. And it was not sufficient per the commission, not sufficient per the Supreme Court, and I understand that. But these leasehold improvements have been made over the course of 37 to 38 years. And they were made when the units were in service to customers.
But this goes back to the point that I was asking Mr. Graves about, and what I was referring to, whether you had seen, where's the deterrent effect on the executives in the executive suite acting prudently on the next big decision if they know that they can get off scot-free without facing any haircut, or maybe even just a minor trim?
Yeah, and I would add that that's a universal concern of the law itself, and one fundamental to, you know, what you refer to as the regulatory compact in your, I mean, right? There needs to be at all levels consequences.
PNM made no money off of the lease expenses, and so that 8-year extension with lease expenses, they could have said, no, we're not going to extend these leases. We're going to go build something, or we're going to acquire something that could be in rate base. And so for those lease extensions, they were leases. They didn't.
But you're answering the question the way that Mr. Graves does his analysis. Well, this happened, irrespective of what the decision was. This happened out there, and so it's a wash. That's your answer. You're not answering the question about what do the executives, and shareholders face for the imprudent decision that the ratepayers are stuck with.
Okay, I thought you were speaking. Okay. I sure would have thought that any remedy would have occurred during that 2015 rate case, especially given the appeals that took place to the Supreme Court. The lease expenses were appealed to the Supreme Court. The Supreme Court agreed with the commission. Yes, it was appropriate to pass those expenses on to customers. And so I would have thought that it would have been addressed there, I guess.
Well, the Supreme Court kicked it back, didn't it?
I think New Energy Economy appealed those lease expenses being charged to customers, and the Supreme Court agreed with the commission that they should be. And the only remedy related to lease extensions was the commission said PNM is not allowed to seek additional decommissioning funding should it be necessary. The Supreme Court said, hey, they need to be heard on that, and that opportunity is on PNM today. So I believe Palo Verde units 1 and 2 leases has been a very good story. And PNM was the first one to do the sale and lease back. Others followed suit. And there was a significant benefit just lately to not pursue acquisition of those nuclear assets and move to renewables. That is something that has changed in recent years. In 2011 and 12, you wouldn't have replaced nuclear power with a battery at that time. I worked at Duke in 2012. They had the largest battery in the country. It was 30 megawatts in Texas. It lasted 4 years and had to be replaced. And so that technology has only advanced in recent years.
Well, that just depends, because like in California, they've got a lot of battery online, and yet they still needed to continue Diablo Canyon, didn't they?
Yes.
Hearing examiner Ryan?
Nothing further.
Yeah, we're just not getting to the point where we address what do the executives face, the same executives who make the determinations on Four Corners and Palo Verde leases and balanced draft. They continue to make a series of decisions, right, without any consequence, it seems. What I hear from the experts for PNM, you and Mr. Graves.
There was significant consequence for the Unit 2 acquisition.
Depending on how you look at what those consequences were, right? How you define the consequences. And you all define the consequences based on what happened that they might have been aware of if they had looked at it, they being the executives.
I know the analysis to abandon recently was appropriate and very thorough. And
okay.
I think, and they made the decision in the best interest of customers. And so I think recovery of those remaining costs is appropriate here.
Thank you, sir. Commissioner
Yes,
Ellison?
thank you, Mr. Miller. Yeah.
Mr. Ellison?
Right. I might take the opportunity, just a couple of additional questions. I haven't had the benefit of looking over that analysis that you are speaking about, Mr. Miller, but do you know if it took into account the 96 million in of undepreciated balance on that 114 megawatts of leasehold at Palo Verde?
So you're speaking about the decision to abandon the 114 megawatts
Yes.
and not acquire that piece at market price.
Yes.
It would not have been appropriate to consider those costs. Those costs were sunk and were not going to be incremental to that decision. And so, PNM was on the hook for those costs either way. And, there was 100 in the analysis that was done at that time based on those RFPs, analysis in early 2020. I remember $170 million in net present value savings to customers to not acquire that nuclear capacity and move forward with solar and battery. And so $170 million in present value savings. I thought that was a very significant number.
I see. And so you're arguing that the 96 million is was money invested and therefore was a sunk cost.
Yes.
But if that leasehold had been repurchased, then that 96 million would have been depreciated over the remaining life of the asset. Is that correct?
The analysis would have assumed that the remaining leasehold improvements would have been recovered either way. If they had reacquired that nuclear capacity or if they had done something else. PNM was on the hook for that cost either way. And so in that type of retirement analysis, you would not include that. But, there was $171 million savings for customers to do something else. It would have only made it better for customers if there was a disallowance on that. But it's very common to not include that type of sunk cost in any retirement analysis.
And on the resource adequacy question, while variable generation wind and solar is, let's say, relatively low on the system, I would think that it would be easier to replace that base load of Palo Verde than it will be when the system is at 50 or 80% renewables. So I'm wondering if the decision took into account the fact that the system, when it's say at 80% renewables, that base load capacity is a lot more valuable and hard to replace than it is today.
I can tell you, I was extremely impressed with Nick Phillips and his team focused on that very issue right there and the increased penetration of renewables. And it is easier to replace 100 megawatts of nuclear than it is to replace thousands of megawatts. But I would also say that nuclear with increased renewables starts to get kind of chunky as well. It does not have the flexibility to help accommodate that duck curve. And so it's just case by case, yes, but whether your renewable penetration is 20% or 80% has everything to do with these decisions.
Right, because right now they're, as the system goes to 80 and then 100% zero carbon, it seems to be unclear where the firm generation is going to come from.
Yes.
And the nuclear is today the only clear source of that firm generation.
Yes. The only challenge is that it can be inflexible. And so, but yes, it's a tremendous source of clean energy.
Okay. Thank you, Mr. Miller. I appreciate it.
Thank you.
Thank you, Commissioner. PNM, any redirect?
Yes, just a few questions. Mr. Miller, there was a lot of discussion about the most recent analysis that PNM conducted in reaching its decision to go ahead and allow the leases to expire and to pursue alternative replacement resources that happen to be renewable and battery. You understand that, correct?
Yes.
And did that analysis that you testified showed a benefit to customers assume that PNM would still recover its leasehold improvement costs that are at issue in this case in the regulatory asset?
I'm not certain of that. I would be very surprised if it did not assume that recovery was going to take place either way.
And even with that assumption, what did the analysis show with respect to relative costs to customers?
The net present value savings to customers, I believe, at that time was expected to be about 170 million is my memory.
There's been a lot of discussion about or a narrative that there has been no penalty as a result of the finding of imprudence with respect to PNM's decision to acquire the 64 megawatts in Unit 2 and extend the leases. Do you agree with that narrative?
In my opinion, there was significant penalty for the Unit 2 acquisition. The remedy that came out of the lease extensions was only a disallowance of any additional needed decommissioning costs. It was overturned by the Supreme Court, and that's at issue today. But
and with regard to the money that PNM is seeking to recover in its regulatory asset, are all those costs related to the period of time in which customers were being served by the 114 megawatt leased interests?
yes, those costs were all incurred by PNM while those leased interests were in service to customers.
In terms of, you spoke, you were asked some questions by Ms. Nanasi about PNM's incentive to reacquire the expiring interests in Palo Verde back when it did so 10 years ago versus allowing them to expire. I think you talked about the fact that, well, PNM only reacquired or repurchased 64 megawatts and then decided to extend the 114 megawatts. Do you remember that testimony?
I do.
And it was by extending the leases as opposed to reacquiring, what effect did that have on PNM's flexibility in the future to look at other resources?
Instead of acquiring, it put them in a position that at the end of that 8-year term, they could walk away from that 114 megawatts of Palo Verde. And so they took advantage of that opportunity here recently.
You've been asked a lot of questions about fairness. Do you think it is fair to penalize a utility for making a decision that benefits customers? And by penalizing, I mean disallowing recovery of prudently incurred costs in the form of the leasehold improvements for Palo Verde's units 1 and 2.
Well, I would say that, of course, the industry is undergoing a tremendous transition right now, moving from large central stations to more distributed sources of power. And, I think recovery of those remaining costs of large central stations is something that can help the transition, help facilitate that transition. And so this was the right decision to not reacquire that nuclear capacity. I think it's the right thing to provide PNM a recovery of and on that investment, given that 37, 38-year service life to customers. And I think it was entirely appropriate. They were depreciating over a longer period, consistent with the operating license. Cheaper alternatives came around, and they took advantage of that.
Thank you very much. That's my redirect.
Thank you, Mr. Alvidrez. Mr. Miller, Commission truly appreciates your testimony. Thank you, sir.
Thank you.
You are excused. Thank you. PNM, would you please call your next witness?
Yes, Ms. Terwilliger will be presenting our next witness. We need a few moments to reseat the witnesses. Do we want to take a lunch break here, or?
No, I'd like to, well, no, I'd like to start with Mr. Casas. And I'm gonna, while that's happening, I'm gonna ask Ms. Nanazi a question about exhibits in the Dropbox folder that I'm confused about. Ms. Nanazi, could you pull up your Dropbox folder, the exhibit exchange? We're just doing this while we're moving over to Mr. Casas. There are two NEE Exhibit 6 in the exhibit exchange for NEE Exhibit 6. Which one is the correct one?
It is the later one, because there was an objection that I didn't put in the first page and the affirmation. And so it's the one from 9/11, sir.
And so the one from 9/2 at 3:28 p.m. we can delete?
Yes, sir.
Okay, I just want to make sure I'm not taking stuff out that should be there.
Judge,
and-
Judge, if I may, there's two exhibit 10s too.
It's the exact same
thank you.
issue. It's the exact same issue.
All right, let's look at those then too. All right, so it's the 9/11/2023 at 9:54 a.m. that should remain, correct?
Yeah. Yes, sir.
Okay. And you will note, all of you out there, that for the administrative notice, overnight and this morning, I went in and I gave all of the administrative notice of exhibits ANs 1 through 75 at that designation, if you look in there, and that correlates to the September 4th order establishing a citation format. AN exhibits, AN stands for Administrative Notice Exhibit 1 through Administrative Notice Exhibit 75 for Commission Administrative Notice Exhibits. Following the citation format in the, I believe it's the September 4th order that Hearing Examiner Ryan and I issued. Just wanted to point that out.
Can I ask a question?
Yes, ma'am.
There is a correction to Mr. Sandberg's testimony, and one is just to label exhibit 24, and because I only realized through cross-examination that one was not labeled. I have a corrected one. Should I email it to you, or do you want me to put it in Dropbox? And there's another one that Mr. Sandberg will say in the record on for exhibit number 3, and that is a wrong number. I think it's says 4 and it should say 9, 64, and it should say 69. And so I want to put that in as corrected. And when we were preparing, so for on his testimony. And so I wanted to know what I should do. Should I email it? I'm happy to email it today.
Yes. At your convenience, go ahead and email it to us and we'll take, because my understanding, you can't upload to the Dropbox folder. We have to do that. So please email your corrections. And I'll make sure that they replace and what we're talking about for replacement is what, any exhibit 1
and 3.
and 3. Okay, great.
Also, there was a question by hearing examiner Ryan, and he wanted to know what GAF stood for. And I looked it up online, and it says the strategist general features, and it says generation and fuel module is what GAF stands for. So I just wanted to say that for the record.
Thank you, Mr. Nazi.
Thank you.
PNM?
Yes, one other thing before we present our next witness. We have confirmed that Mr. Gray and Mr. Sanders are available Wednesday morning.
Wednesday morning.
I apologize. Friday morning.
Great. Thank you, Mr. Alvidrez.
Thank you.
We'll look forward to seeing them first thing then Friday morning. Probably Sanders first and then Mr. Gray, if that's possible. Thank you.
And Commissioner Ellison, can you confirm that you heard that, sir, and that you're ready? You'll be with them 9 a.m. on Friday, if you're at your. Otherwise, he may have just left it on mute to go. I'll send him an email.
Okay. And Mr. Gould, before we call Mr. Casas, do you have about 20 minutes of cross, or what are you looking at for a good breaking point? Because I'd like to start Mr. Casas and then break for lunch sometime around 12:15 or 12:20 or 12:30, depending on what works for your cross-examination.
That would work. I have several stopping points, but before we start, if I could and maybe we'll get Mr. Casas sworn in. I just need to double check with you, sir, on what the minutes are that we have remaining for Mr. Casas.
I have you list. I'm sorry.
Go ahead.
I have you listed at 95.
95. And what if we switched things around? If you can just tell me very quickly what your matrix shows for Mr. Phillips.
165.
Okay, thank you. Yes, I do have a stopping point that we can, and I'll adhere to the 12:15.
Okay, so I'm going to start you up here at 60, 70, 80. I'm going to put you at an hour and 35. And again, are you going to have Ms. Gould, your co-counsel, on with you?
She is going to be, yes, she's going to be putting the documents up on the screen.
I just asked her to make sure that or somebody to tell me to pause, remind me to pause at the lunch break and at breaks. But I have you starting now with Mr. Casas after he's sworn in at an hour and 35 minutes. Does that sound about right?
Yes, sir. That sounds accurate.
Okay.
Thank you.
PNM, Ms. Twilliger, would you please call PNM's next witness?
PNM calls Mr. Casas. Can the witness be sworn, please?
Would you please raise your right hand? Solemnly swear the testimony you're about to give the matter not opinion should be the truth, the whole truth, nothing but the truth.
Yes.
Thank you, sir.
Good morning, or what's left of the morning, Mr. Casas. Can you state your name, spelling your last name and your title for the record, please?
Yeah, my first name is Abraham. Last name is Casas. That's Casas. My title at PNM is Senior Pricing Analyst, and my employer is Public Service Company of New Mexico.
Thank you, Mr. Casas. Do you have what's been marked as PNM Exhibit 43, which is your prepared direct testimony in front of you, filed on December 5th, 2022?
Yes,
And was PNM Exhibit 43 prepared by you or under your direction?
yes, it was.
And does PNM Exhibit 43 reflect the errata corrections previously filed by PNM?
Yes, it does.
Okay, do you have any additional corrections to PNM Exhibit 43?
No, I don't.
Is this testimony true and accurate to the best of your knowledge?
Yes, it is.
Have I asked you the same questions today? Would your answer be the same?
Yes.
Okay. I request admission of PNM Exhibit 43, please.
Any objection? Hearing none, PNM Exhibit 44 is admitted. 43, excuse me, is admitted. I've jumped ahead.
All right, Mr. Casas, do you have what's been marked as PNM Exhibit 44 in front of you, which is your rebuttal testimony filed on July 28th, 2023?
Yes, I do.
And was that prepared by you or under your direction?
Yes, it was.
And are the changes or is the PNM Exhibit, does PNM Exhibit 44 reflect the errata that you filed prior to this hearing starting?
Yes, it does.
Any additional corrections to PNM Exhibit 44?
No.
Is this testimony true and accurate to the best of your knowledge?
Yes, it is.
If I asked you the same questions today, would your answers be the same?
Yes, they would.
Thank you. PNM request admission of PNM Exhibit 44, please.
Is there any objection? Hearing none, PNM Exhibit 44 is admitted.
Thank you. I tender Mr. Casas for cross-examination.
Thank you, Ms. Terwilliger. I have New Mexico area first. Mr. Gould, please proceed.
Thank you, Mr. Hearing Examiner. Good morning by I think about 60 seconds, Mr. Casas. How you doing today?
Doing well, Mr. Gould. How are you doing?
I'm well. As you understand, I represent Animaria, which is a coalition of large customers on PNM system. You understand that?
Yes, sir, I do.
Okay. Just as a preliminary matter, you don't have a law degree. You're not an attorney, are you?
No, I'm not.
Is it your intention in your testimony to give a legal opinion on any matter?
Legal opinion, no.
Okay. You are the sole sponsor of PNM's cost model, are you not?
Yes, that's correct.
And the output of the cost model is found in your direct testimony at your exhibit, PNM Exhibit AC3. Do you see that?
Yes, that's correct. AC3.
And that is my statement correct that this is the output of the cost model, that AC3?
Yes, you're correct.
Okay. And I looked through your errata. You have not changed any of the numbers in AC3, have you?
That is correct. No numbers have been changed
Okay.
for the AC3.
And it's quite an extensive exhibit. So when we get into it, what we will do is specify not only the tab and the name of the tab, but also the PDF page number. Is that a fair way to go through that really lengthy exhibit?
I think that's the best way to go through that kind of exhibit, yes.
And you have access to a PDF copy where you can see the page number when I give you the page number. Do you have that access?
I do. Yes, I do have
Okay,
access.
cool. Okay, well, I want to start with some more general questions. The purpose of the cost model is to correctly and accurately define customer class responsibility for PNM's non-fuel costs. Is that an accurate statement?
I would say, yes, that's an accurate statement.
Okay. And I'm going to read a statement and see if you agree with it. If you disagree with it, please tell me. And one of the other things I want to say at the outset, if you don't know, just tell us. I mean, there's no none of us know everything, and this is a very complicated case. So if this is not your area of expertise, when I mention something further on in my cross and you say, well, that's better for somebody else, or I don't know it, I've not done that research, or don't have that background, please let me know. Okay, that'll make our job so much easier when we go through this. Is that a fair way to proceed?
Yes, sir, that is.
Okay, thank you. I'm going to read this statement. The output of the cost model should be designed to provide the commission with an accurate picture of what non-fuel costs P&M incurs to serve each rate class. Do you agree with that statement?
Can you repeat it again?
I will. The output of the cost model should be designed to provide the commission with an accurate picture of what non-fuel costs P&M incurs to serve each rate class.
I would say that's an accurate statement.
Would you also agree that in the cost model, there should be no embedded interclass subsidies hidden within that model?
I would agree. There shouldn't be any interclass subsidies, but again, when it comes to allocating costs within the cost model, allocations are not designed with, interclass subsidies built in them. Although some allocators might, you'll have different winners and losers, depending on which allocators you use, but allocators are not designed to, create interclass subsidies.
Okay. And you agree that, and I believe it's your testimony in this case that your AC3, the output of the cost model should be fully transparent. In other words, the commission or an intervener ought to be able to go in and figure out what's going on with those allocators, correct?
Correct.
Okay. I'm going to kind of change gears a little bit and ask you about the energy storage resources that have sort of become a point of contention between my client and yours, as you're aware. And again, this is a complicated area. So if I ask you a technical question that's not within your area of expertise, please let us know. Would you agree that the energy storage systems that P&M is requesting recovery for in the 2024 test year are all located at the site of an energy production resource?
That's my understanding that they're at I believe they're interconnected at a solar site.
Okay, all of them. All of the ESAs. Let's
Yeah,
start with that.
that's my understanding, yes.
And then all of the P&M on the batteries, the 12 megawatts of proposed P&M batteries, those are also located at a solar production site. Is that correct?
I believe so.
Okay. And would you agree with the statement that energy storage systems do not operate independently from P&M's generation or production resources?
May you repeat the question, Mr. Gould?
Yes. Energy storage systems do not operate independently from P&M's production resources.
I don't know if I would agree with that. I don't think do not operate independent. I don't think battery storage operates in tangent with our traditional production resources. So no, I wouldn't agree with that.
Let me ask a clearer question then. It is true, is it not, that in order for an energy storage resource to operate, it has to be charged from a production resource?
it does have to be charged, and subject to check, I think these batteries are being charged from renewable resources.
Were you aware that they're also capable of being charged from the grid? In other words, from multiple sources on the grid, in addition to the solar where they're located?
Generally aware, just of my understanding of how, my general understanding of batteries.
Okay. And that means that those battery resources can be charged from any production resource or facility that is connected to PNM's transmission grid. Is that your understanding?
That they could be charged from?
Yes.
I would say yes, that's a fair statement, that they could be charged from.
Okay, so, and PNM has a lot of various resources on its system. It has nuclear, it has combined cycle gas, it has some coal. So theoretically, at least, these battery resources could be charged from any one of those generation resources. Is that your understanding?
Again, I don't, I just have a general understanding of how batteries work. If those resources are, producing power on the grid, I would think they'd be able to be charged from those resources.
Well, let me ask you a foundation question then. Do you have any understanding from your work at PNM of how the various generation resources on PNM system operate?
Yeah, from my work here at PNM and, revisiting the previous, ECOS models from previous filed rate cases, and working on this case, I do have, I guess, a high level understanding of PNM's production system.
Well, let me ask you then a high level question. Do you understand that each one of the different types of generation that PNM has on its system have different operational characteristics? In other words, they provide a different type of power or a different time frame where they offer power, or they provide a different kind of support for PNM system. Do you understand that generally?
I would think that, different resources are utilized possibly at different times. But I guess, they're producing power. It's just, right. That's at the end of the day, they're used to produce power. And I just, I would think they could be utilized at different times. But I think the specifics, that would be more of a operations individual.
Let me ask you just one last general question, then I'll move on, which is, in your cost model, have you, aside from the batteries, which we will talk about, have you proposed a different allocator for the nuclear production versus, say, for instance, the quick start gas turbines on PNM system?
No, the only different allocator that we're proposing in this case is for ESAs, and that's our modified 3 summer 1 winter allocator, which I did cover in my testimony.
Sorry for stepping on your testimony. Did you finish your answer?
Yeah, I was just saying that I do cover that modified allocator in my testimony.
And we must be communicating telepathically, because that's the next place I was going to go. Let me ask you a few questions about this, then we're going to take a break and we'll come back to it. But I think we can make this a separate couple of questions. So as you stated, PNM's ESA battery resources, that is the energy storage agreement battery resources, are the only production resources that PNM is seeking to allocate using a different allocator. Is that a fair statement?
That is a fair statement. In our current proposal, the energy storage agreements, ESAs, are currently using the modified 3 summer, 1 winter allocator.
The 12 megawatts that is proposed to be PNM owned batteries, however, you are not proposing to use the modified 3 summer, 1 winter allocator, are you?
Correct. The 12 megawatts, those are being allocated to the customer classes on our unmodified 3 summer, 1 winter.
Which you use for all of your other production facilities. Is that a fair statement?
Yes, the unmodified 3 summer, 1 winter allocator is what we use to allocate our production assets.
Okay. If you know, the ESA batteries and the 12 megawatts of PNM owned batteries are the same technology, are they not?
My understanding is that, yes, that they are. That's my
Okay.
understanding of the batteries.
And if you know, they would be charged by the system, both of them, and they would have very similar discharge times. Is that your understanding?
Yeah, and so that is my understanding. And the reason we have our PNM owned batteries treated differently than the ESA batteries is our PNM owned batteries. They're booked by Mr. Sanders as a production asset under the FERC Uniform System of Accounts. And because they are, my understanding of these batteries is that they do provide benefits to multiple functions. So they do provide a benefit at the production level, and because they're booked under production plant, we left them as is and functionalized them to production, classified it as 100% demand, and they're being allocated just on our traditional 3 summer, 1 winter allocator.
And referring to these batteries, you're talking about the 12 megawatts of PNM owned.
Correct.
In your last answer.
Correct.
Mr. Hinghammer, that's a good stopping point for me if that would work for you.
Yes, that would work for me. Hearing Examiner Ryan? Okay, let's
Yes.
go ahead then and break. I'll pause right now at 1:18:51.
Thank you.
And we'll be in recess until 1:15. Have a good lunch, all.
David, this is Mr. Albright, just checking to see if you can hear me. I've had some ups and downs with my audio here today.
Yes, yes, sir, you're good.
Yes. All right, thank you.
Mr. Maderos, I do have a little procedural matter to discuss. It'll take me 30 seconds before we get back on with our cross of Mr. Casas.
Thank you, Mr. Gould. Go ahead.
Well, I want to make sure we're back on the record because it is going to be a record issue.
All right.
Okay, thank you.
Back from lunch on this day 8 of PNM rate case hearings. Mr. Gould, before you resume your cross-examination of Mr. Casas, I believe you have a procedural issue to address.
Yes, sir. I had a telephone conversation with Mr. Williger over the lunch hour. We're going to use the responses to PNM's responses to NM area interrogatory 18-3 as an exhibit in the cross-examination. And Mr. Williger and I had a conversation and realized that in my redacting of the response, I took out an introductory paragraph that provides context to the table that we want to put on the record. And so after I spoke with her, I corrected the exhibit. And so the one that I sent out this morning is not going to be the one I use. It's going to be the one that I sent out about 15 minutes ago.
Okay.
Okay.
I didn't see that yet, but it must be right here. I'm checking my inbox.
Yeah, and I'm sorry for the last minute, but it doesn't change much. It's just it's well, Mr. Casas, I don't want to
Okay.
I don't want to
what I'll do-
testify in his place. He's the expert.
Well, what I'll do is I'm looking at your Mexico area cross-examination exhibits. And I put 46 in there this morning, I believe. I'll take that one out and replace it with the one you just sent about 15 minutes ago. Is that
Yes, that will work. Thank you, sir.
okay? Although I don't see 46 in there right now. In any event, this one will be in there.
What I did is I attached it to the same email and forwarded it just so that I would catch all the same parties. So it should be attached to the latest iteration of that email that I sent this morning. If not, one more boo-boo on my part and I'll have to go resend it in a break.
So let's see, I'm looking at the exhibit now. And the one that you just sent at 12:59, and there's still a redaction, but that's an appropriate redaction on page 2.
Yes.
Exhibit. Okay.
And on page 2, and then in the response on page, the page numbers aren't in there, page 3 as well.
There's a redaction there, but okay, but this is the correct exhibit. Is that right, Ms. Terwilliger?
I mean, yes, I am fine with this exhibit. Obviously, there's more context to that, but I'll let Mr. Gould do his cross-examination and then I'll see if I have redirect.
Of course. Okay. Well, with that, then I will place this 46 in the New Mexico area cross-examination folder. And is there anything else to address before we get back to Mr. Casas?
Well, just as a note, what we've tried to do is follow the format with these interrogatory responses. So it does have the first page. It does have the interrogatory and the response, and the last page is the self-affirmation of Mr. Casas.
Okay, and that's to provide sufficient context for the exhibit.
Yes.
Okay. Well, then let's proceed with the cross-examination, Mr. Casas.
Thank you, sir. Mr. Casas, when we left, we were talking about the modified 3 summer 1 winter allocator. Do you recall that?
Yes, I do recall that.
Okay. Would you tell me what the unmodified 3 summer, 1 winter allocator is for context?
Yes, so the unmodified 3 summer, 1 winter allocator is our class allocator that we use to allocate production demand costs to all of P&M's customer classes. And what this allocator is doing is the way it's derived. So we're looking at 3 summer months, which are June, July, and August, and 1 winter month, which is December. And what we do to derive this allocator is we're looking at the 4 hours, the system peak hours in those 4 months, and we take the CP demands of each customer class for those 4 hours, and we average them out, and that's how that the unmodified 3 summer, 1 winter allocators is derived.
What do you mean by the abbreviation CP?
CP stands for coincident peak, and I'm sorry, go.
No, finish your answer. I'm sorry.
Yeah, no, I was just, so again, CP is for coincident peak, and what that means is we're looking at the customer classes coincident peak demand at the system peak in those 4 hours.
Okay. And that's called the on-peak coincident peak hour or hours right there, those 4 hours during the year, right? I think you've frozen up.
I understand it.
He did freeze for a moment.
Am I back? I understand it. Am I back? Can you guys hear me?
Yeah, there's lag still. Wait, Mr. Gould, Mr. Costas, can you hear me clearly? You just say hello to us all. Make sure you're.
Can you guys hear me?
Yes, but you did lag out there for a
Oh.
second, and then just FYI, Zoom, if you do lag, it'll pick you up and then plays you on fast forward, and it can be impossible for the court reporter to pick up what was just said. So, Mr. Gould, why don't you go back to where the problem started?
Yeah, let me just, my question was unclear, so thank you, Mr. Hearing Examiner. I'll ask a clearer question. Those 4 hours in the 4 peak months are called the CP or coincident peak hours, are they not?
No, the 4 hours that we're looking at are the system peak.
Right.
So that's when P&M system had the highest demand on their system at those 4 hours. What the CP coincident peak is referencing is that's referencing the customer classes demand at the system peak hour.
You are correct, and thank you for correcting me. That was why my question was unclear, but thank you for that correction.
And Mr. Gould, if I might, Mr. Costas, if I understand correctly, that's based on his data historical averages. Is that correct?
No, so for for the test year, we're basing it on the forecasted data. So for this case, our test year is calendar year 2024. So the test year CP demands are based on the forecast that our team receives from the forecasting group. For the base year, we are looking at actual usage.
But the way that they determine the different classes coincident peak would be looking at how it had been in the past and then projecting out forward through forecasting and then making adjustments as needed. Is that basically a true statement?
I think that's more of a question for the forecasting group or Stuart McMenamin, but my understanding of the forecast, they do use, I'm guessing, actuals that feed into the test year. I have a high level understanding of how the forecast is prepared, but I think they do start with actual usage to get to a test period.
To extrapolate out to a test period.
Correct, yes.
Okay, thank you for that clarification. That's very helpful. So the modified 3 winter, 1 summer, God, I keep on doing this. The 3 summer, 1 winter allocator is intended to capture what happens after that peak hour, right? In other words, the non-peak hour.
So it's intended to capture, and I wouldn't call it, I wouldn't state it as the non-peak hour, just because the modified 3 summer, 1 winter is still looking at a peak hour per se, not the system peak, but it's looking at the peak dispatch hour of battery storage.
Okay, well, let me ask a better question. It's the modified 3 summer, 1 winter allocator is not looking at the highest hours on PNM system. It's looking at some other hours, right?
Yeah, so the modified 3 summer, 1 winter is not looking at the system peak hour. It is looking at the peak battery dispatch hour.
On page 16 of your direct testimony, would you turn there right at the bottom of the page? I'm looking at lines 21, 22, 23, and on to page 17.
Okay, I'm there.
You talk about the modified 3 summer, 1 winter allocator, CP allocator, and then you state this modified allocator does not apply at system coincident peak. Is that still your testimony?
Yeah, that's still my testimony. I think we could have been a little clearer on explaining, but I mean, it's still true. The modified allocator is not at the system peak. So it's not looking at the CP for all customer classes at system peak. So yeah, I mean, that's still my testimony. Could have been a little clearer, but yes.
Is there
And the
anywhere?
Mr. Gould, the peak dispatch hour, is that 9
Well, that's what I
PM
was going to
Mountain
ask.
Standard
next.
Time? Oh, I'm sorry.
No, you guys are ahead of me. So yeah. So what are the hours, or what is the hour that is used as the highest hours in each of those months? I didn't see that in your testimony.
For both the system peak.
No, for the system peak and then the coincident peaks of the classes. I assume it's the same hour. What hour is that for the regular 3 summer, 1 winter allocator?
Yeah. For you. So for the unmodified 3 summer, 1 winter, for the month of June, that was our beginning 17. For the month of July, that was also our beginning 17. For the month of August, that is our beginning 16. And then for the month of December, that is our beginning 19. So for the unmodified 3 summer, 1 winter, we are looking at, for all the customer classes, we are looking at the CP demands at those hours. We're looking at those 4 hours for each customer class. And then we take the average of those 4 hours, and that's what we use to derive their unmodified 3 summer, 1 winter.
You're muted, sir.
I dropped a book on something. Are these hours adjusted for daylight savings time?
My understanding of when we receive the forecast, that forecast is in Mountain Standard Time.
So the June hour would actually be an hour later? I'm just trying to understand exactly what we're talking about here, or an hour earlier. I guess maybe a better question is, so if it's the 17th hour, that's 5 o'clock in the evening. Is that 5 o'clock in the evening of Mountain Daylight Time? Or is it some other version that doesn't account for the daylight time adjustment?
So I think so our forecast is in Mountain Standard Time. If it were to be Mountain or the time on the clock, that would be an hour later, I believe, if it was Mountain prevailing.
Okay. So we'll just move on and we can come back to that if we need to. Are these the same hours that Dr. Pitts is using for her time of day pilot program? And in her peak and off-peak hours? If you know.
Yeah, that I'm not too sure. You might be a better question suited for Dr. Pitts.
And then, so what are the modified 3 summer, 1 winter hours for June, July, August, and December?
Yeah, so the modified 3 summer, 1 winter hours. So for June, it would be hour beginning 21:21. For July, it would be hour beginning 21. For August, it would also be hour beginning 21. And then for December, it would be hour beginning 18:18.
Okay. You had stated in your testimony that since you didn't have actual data, PNM has developed this modified 3 summer, 1 winter using a simulation, which comes from the work that's being done in the integrated resource planning docket. Is that a fair statement?
My understanding is that the model that was used, the SURVEM model, is, I don't know if it's the only model that's used in those filings, but I know it's one of them from what I recall.
Okay. Has that IRP case been filed at the commission, if you know?
I don't know.
When did you first speak with the person that did the simulation about incorporating the modified 3 summer, 1 winter into your cost allocations and cost functionalization?
Let's see. I think we started talking about the modified 3 summer, 1 winter allocator. If I recall, I mean, obviously it was before we filed on December 5th, but maybe, I'm not too sure, maybe a month and a half, 2 in advance before the filing, maybe.
But it was fully developed and in your mind ready for filing by December 5th.
It was ready by the filing, yes.
Okay. Has as far as you know, has the survey, well, let me ask a better question. The cost model that you're using to functionalize and allocate has been shared with all the parties, right?
Correct.
In a usable fashion so that my witnesses were able to go in and change some of the data assumptions and come up with their own cost allocators and functionalization. Is that a fair statement?
Correct. The cost model was included in the USB flash drive that was provided with the filing back on December 5th.
At no cost. There was no license fee, was there?
It's an Excel-based model, so as long as you have Excel on your machine, you should be able to run the model.
So no additional cost to the parties in the case. Is that a fair statement?
I'm not sure if any parties had to get Microsoft products, but yes, I guess that's fair.
Okay. Was the SERVIM model provided to the parties and the staff in the same way?
That I recall, no, it was not included on that flash drive.
You have included in your testimony, as we talked about, AC3, which is the output of the cost model. Is there a similar exhibit that was filed on December 5th with the application that has the output of the SERVIM model that was used to create the modified 3 summer, 1 winter?
Not that I'm aware of.
Okay. Have you run, independent of the IRP process, have you run the SERVIM model yourself?
No, sir, I have not.
Can you describe the SERVIM model for us?
I would not be able to describe it for you. That's a better question for Mr. Phillips, as he's the one who runs that model and ran the simulation.
I understand that, but you're supporting the results of incorporating that modified 3 summer, 1 winter. You're supporting the incorporation of that into your cost results, are you not?
I'm supporting the output of his model. And, my general understanding of the output is that, these batteries are capable of, discharging at their full capacity. But what the simulation, the output showed was that, they discharged 70% and 30% was held back for ancillary services related to transmission. And then the 3% that we have functionalized and classified as distribution, that was kind of a placeholder. From what I understand, that the model does not go down to the distribution level.
I guess my question is more basic than that. Were you able to check the correctness of Mr. Phillips' work independent of Mr. Phillips?
No, again, Mr. Phillips is our in-house expert. He's the one who ran the model, and I just, for my function in this case, I just needed to apply the output, which were the percentages I talked about earlier.
I understand that, but you basically, without checking his model, incorporated what he said were the outputs into your cost model. Is that a fair summary of what happened?
Yeah, I would say it's a fair summary. I did not do a quality control or review Mr. Phillips' SERVIM model. But I am incorporating the output into the model.
And is that your full answer? I didn't want to step on you.
Yes, that's my.
Okay, thank you. I was going to, well, let me just, I'll ask my next question, and if you don't know, then we'll move on. I'm going to briefly describe what I understand to be the SERVIM model and its functionality, and see if you know any of this independently. The SERVIM analysis involves thousands of simulations of PNM system performed in 5-minute intervals that take into consideration the uncertainty of weather, load forecast, generator outages, intra-hour volatility of intermittent resources, and hourly power purchases and sales transactions with neighboring utilities. Does any of that sound familiar to you?
Objection, Foundation. I think Mr. Costas has been more than clear that while he's sponsoring the output of the survey model, he did not run the model. This is a question for Mr. Phillips, who is a witness in this case.
Response?
I'm just asking Foundation. I'm not asking him. I'm asking, does any of this sound familiar?
Mr.
Overruled.
Oh, sorry.
Again, Mr. Gould, I was not involved with running the model, the survey model. I'm not too familiar with it. Just for this function, or for my function in this case, I just needed to utilize the output.
Okay, we'll move on. You used the survey result, the modified 3 summer, 1 winter, in 2 very distinct ways in producing your results. And I want to walk through those. And if I get it wrong, because you're the expert, tell me, okay? The first way you did it, the first use you made of it was in the functionalization step. Is that a fair general statement?
Yeah, I would say that's a fair statement.
And I'm going to come back to what you did. The second use you made is in the allocation step of your analysis. Is that correct?
Well, I guess going back to your first step, we used it in the functionalization and classification. And then, yeah, the second step, we use it to look at the modified hours for class allocation. So yeah,
Okay.
I would say that's a fair statement.
Going back to functionalization, what you did is you used the model to functionalize only the energy storage agreements, 30% to transmission demand, 67% to production demand, and 3% to distribution demand. Do I understand what you did correctly?
Yeah, I just want to clear things up, just because functionalization and classification are sometimes used interchangeably. So we functionalized it as production, transmission, and distribution, and then we classified it as 67% production demand, 30% transmission demand, and then 1% in distribution substation, 1% distribution primary, and then 1% distribution secondary.
Okay. Would you go in AC5 to PDF page 201 of 298 in your testimony?
This is the rebuttal?
No, this is the direct testimony.
Direct. Okay.
And if we could get it just slightly larger. Yeah, that's good, right? Up, back down 1 step. Thank you. I want to turn your attention, and I'll describe this and see if you agree. It is one of the tabs in AC5, and it's called Cost of Service Test Year tab, and we're on page 45 of 48. Are we on the same page?
I'm getting there, sorry.
Okay, let me know when you're there. I don't want to rush you.
Mr. Gould, I assume you mean AC3, not AC5.
I need somebody to stand next to me and rap me sharply on the head, because AC3, pardon.
We're suffering the same affliction, Mr. Gould. I may have given it to you today. I'm sorry.
It is an affliction, isn't it? I think it came from trying to say contribution to production component too many times on Friday, or whenever the heck we were last together.
So on the PDF that we have, is it page 81 of 298?
No, it should be page 45 of 48. So it's PDF page 201 of 298. Did I say that right, or did I?
No, it's 201. You're right.
Yep.
Yeah.
Yeah, it's 201.
Okay. What I want you to look at, if you're there, is the column that says total non-fuel revenue requirements.
Okay, yes.
And that is in all of those buckets of costs. If we add all of them up, you get the total non-fuel revenue requirements of 790,979,680, which is PNM's revenue.
I'm sorry, can you give me the number again? 790?
I'll start again, Mr. Lee. 790,979,680. Do you see that, Mr. Casas?
Yes, I see that.
That is the total revenue requirement for the test year that PNM is requesting in this case for its non-fuel or non-fuel revenue requirements, correct?
Correct. So between line number in 18 and 19, you have, you have PNM's total non-fuel revenue requirement for the retail jurisdiction. And then you could see it's broken out by our functional components. So starting with production demand and then ending with distribution customer other. But yes, those numbers will add up to the 790, 979, 680.
Okay. And the top line, which is the production demand, do you see that?
Yes, sir.
That number is 287,370,135, correct?
Correct.
And in that number is the $11 million in test year cost for the 12 megawatts of PNM owned batteries, correct?
Correct.
And in there as well is the 67% of the ESAs.
Correct. That's going to include ESAs as well.
And then
But it's going to include 67% of ESAs.
Yes, it's going to include the 67% that we functionalize as production and then classified as production demand.
do you recall off the top of your head what that 67% is, what the dollar figure?
It's around 30 million. And I could point to you where we could see that breakout of the ESA batteries.
Okay,
Yes,
30
please.
million. Yeah, could you
Please
point
do.
that out?
I'm
Yeah.
sorry, Mr. Gold. It's
No, go-
interesting stuff.
No, absolutely. We got to get it right. So Mr. Casas, respond to the hearing examiner's question, would you please? And you had made an offer?
Yeah, so if you go to the PDF page 206.
Okay.
And I'm just gonna, this isn't the page where it shows it, but I just want to explain the layout, and then I'll point you where the ESAs are located. So on this page, you'll see we have, all of our cost items under plant and service. And then we're going to have an account number, total company, which is a total company revenue requirement, our jurisdictional allocator that's used to break it out into retail. And then you have PNM retail. And then to the right of that, you're going to see our functional / classification allocators, which is what breaks it out into either production demand, production energy fuel, production energy non-fuel, all of our functional buckets. And I just wanted to show the layout of this, of what we're going to see. So if you go down to, let me find the ESAs first. Fuel related, non-fuel. Okay, so if you go to page 218,
And what is the number at the top of the page? Is it?
it is page 13 of 36.
Okay, thank you.
So here you could see it's the same breakout that I was explaining earlier. And if you look at line number 5, you'll see under operations and maintenance, you'll see energy storage agreement demand. And if you keep going to the right, you will see the 30 million under production demand. So that's the 67% that's being classified as production demand. And then if you keep going to the right, further to the right, you'll see the portion that's classified as transmission demand. So that's the 30%.
Okay.
And then on to the next page, you will see the 1% that's allocated or classified to distribution demand substation, distribution demand primary, and then distribution demand secondary.
Okay. Thank you for that. And going back to page 201, the 13.5 million that you just pointed out, which is the 30%, would be in the line item that says transmission demand, and the dollar amount is $106,036,783, correct?
Yeah, so the 30% of ESAs that's classified as transmission demand will be in that number you just read out, the 106,036,783.
Okay. And that number, do you agree that that amount represents the total revenue requirements associated with the total capacity of PNM's transmission system?
Yeah, that's fair. I mean, that number represents PNM's revenue requirement related to transmission demand. So yeah, I would say that's fair.
And that's the number that you're using to set your transmission demand rates in this case, correct?
Our transmission demand rate for
your entire, all classes.
For 36B, but I think.
No, I'm talking about everybody.
Yes, it's going into the demand rate.
Okay.
It's going into demand.
Into the demand rate.
Thank you.
And if you go down 2 lines, you have a number of 119,369, which is the distribution demand primary. Do you see that?
I see that, yes.
And that's the number that represents the total revenue requirements associated with distribution demand primary that you're using to set rates in this case. Is that a fair statement?
Yeah, that's a fair statement.
Okay. And then moving back up to production demand, that 287,370,135 is the production demand revenue amount that represents the total revenue requirement associated with the total capacity of PNM's production system that you're using to set rates for all customers, correct?
Yes, except for, and I think Ms. Chan touched on this in her testimony, or when she was testifying. We for the 36B customer, we are calculating 2 components. We have the ESA, production demand related to ESA only, and then we have production demand for all other assets.
Yeah, I understood that from that questioning. We're not going to go back through that. I think we pretty much exhausted that with Ms. Chan. The if you took that entire amount in your cost model of $287,370 and 300, let me start, $287,370,135 and allocated it according to the unmodified 3 summer, 1 winter, PNM would recover that entire revenue requirement if the commission agreed with your total revenue requirement. Isn't that a fair statement?
So you're saying if we didn't use the unmodified, or I'm sorry, if we didn't use the modified 3 summer, 1 winter, would we still collect that same amount? Is that what you're asking?
Well, I'm asking a more specific question, so let me ask it again. If you took that amount that we just put on the record and allocated it according to the traditional 3 summer, 1 winter, and let's assume the commission approved your entire revenue ask of 790 million. If you used the unmodified allocator for that particular portion of the costs, you would totally recover those costs, would you not?
Yes, because again, it's just that the modified 3 summer, 1 winter that's being used for the 67% of production demand related to ESAs, that's included in that production demand dollar amount of 370,135. So if we didn't use that allocator and we used our unmodified 3 summer, 1 winter allocator, we're still going to collect that same amount. It's just going to be, allocated differently amongst the classes.
Right.
Yeah.
So if we haven't covered it already, let's go to the second usage, because you've mentioned this, of the modified 3 summer, 1 winter. That allocation is where you actually assign, you take the 67% of the ESA that you put in the production demand and you assign them differently from all the other production demand costs, right?
Can you repeat your question, Mr. Gould?
Yeah, let's start again, just so we're clear. What you've done in the functionalization and the classification is you have taken 60%, 67% of the ESA costs and put them in production demand, right?
Correct.
And then you've taken 30% and put them in transmission demand. And you've taken 3% and put it down in those distribution categories, right? So that was the first step, right?
Correct, yes.
Then what you did is you use that same modified 3 summer, 1 winter to go to just the production demand number of 287 million. You've broken out the 30 million and change of ESAs, and you've applied this modified allocator just to that portion of the production demand total revenue requirement. Is that a fair statement?
I think I understand your statement. So yes, we only applied the modified 3 summer, 1 winter allocator to the 67% of production demand that's related to ESAs. Yes, that's the only cost that we're using the modified 3 summer, 1 winter allocator on.
And the reason that the rationale for doing that is that you say that these ESAs operate in a way that's fundamentally different from every other asset in the production demand bucket, right?
Right. And, that's what we relied on the simulation for, is to kind of guide us how these battery assets are going to be going to be utilized on PNM system.
And your basic testimony is that they're used for ancillary services, right?
No, I think in my testimony, you know, I talk about that they're discharging at an hour different than the system peak hour, and which is why PNM, you know, we felt it was appropriate to develop this new modified 3 summer 1 winter.
But you didn't look at any of the other production assets and see if they were producing energy at hours that were different from the other production assets, did you?
So
that's a yes or no question. Did you?
Again, I was just going to go back to the PNM owned batteries. That would be the only other asset that would be, you know, discharging at a, you know, something similar how we treated ESAs.
Yeah, but you didn't allocate those according to the modified 3 summer 1 winter, even though you're stating now that they operate in the same way.
Right. And I think I stated earlier that, you know, the way we have them, you know, we're following how they were booked according to the FERC uniform system of accounts. They, you know, given that battery, you know, batteries are, you know, might provide, they'll provide benefit to multiple functions, you know, the production function, transmission function, distribution function. The way we have them, the PNM owned batteries, the way we currently have them treated is appropriate, but they, you know, going forward, I think they should follow something more similar to that of ESAs.
But you don't know because you don't have any production data. This is all based upon a simulation. Isn't that a fair statement?
Yeah, at the time of the filing, we didn't have any battery in our system. And we relied on the simulation to kind of guide us on the way we functionalize and classify these assets.
Did you ever talk to Mr. Heffington who's the manager of production at PNM about how all the production assets operate?
I don't recall talking directly to Mr. Heffington. I know I've had calls with other individuals from ops, but I don't recall having a direct phone call with Mr. Heffington.
Do you understand that, say, for instance, the Palo Verde Nuclear Generating Station, which is an asset that is included in that 287 million, operates in a fundamentally different manner than PNM's quick start gas plants and provides different capabilities and different benefits to the system than the gas plants? Do you understand that?
No, I'm probably not too familiar with that.
Okay, well then let's just move on. You were referred, and Mr. Hearing Examiner, what's my time now? Is it 35 minutes?
Yes.
Okay. Thank you.
34 plus.
Okay, thank you. Appreciate that. Mr. Casas, I next need you to turn in AC3 to page 259 in the PDF version. I think it's one page back. Yes, right there. And I'll read this is the tab that's entitled FUNC Factors Test Year and I'm looking at page 1 of 10. Are we on the same page?
Yes, we're on the same page.
Okay. What I want you to look at is, let me get my ruler here. I want you to look at line 4, which is called demand production. Do you see that?
I see that, yes.
And you see a column that says total company, and it has the value of 1.0 and then a number of zeros after that. Do you see that?
Yes, I see that.
And then it says the next column is retail, P&M retail, and has the same 1.000 on out. Do you see that?
I see that, yes.
My reading of that is that the entire production demand is assigned, P&M's entire production demand is assigned to the retail customer. Is that how that's supposed to be read?
That's my understanding. Again, these are, the jurisdictional ratios that Mr. Sanders used to get P&M's total company revenue requirement to the retail jurisdiction. But yes, that's my understanding of that 100, all of demand production will go to the retail jurisdiction.
So the 1 stands for 100%, basically.
That's my understanding, yes.
And the cost model uses these numbers to develop its retail allocation of P&M's total costs, right?
Right. So if you recall the page I was showing you guys earlier to get to the ESAs and how they were functionalized and classified. So in AC3, and I think the tab is called the functionalization tab, that will have a column where it breaks out P&M's total revenue requirement, and then it uses, it'll use these jurisdictional ratios, which are the same ones that Mr. Sanders uses in his KTS3 model. So yes, it'll break out from total company revenue requirement to P&M retail, and then it's the retail jurisdiction revenue requirement that I begin to, run through the cost model.
Okay. Would you go down a couple of lines, line 6, and it says demand dash transmission. Do you see that?
I see that, yes.
And the P&M retail is, the fraction is 0, or the decimal 0.45749. Do you see that?
I see that, yes.
Does that mean that on a demand basis, retail customers are using approximately 46% of the transmission system?
Of that transmission system component.
Yeah, that transmission system component, the demand component.
I think that would be more a question for Mr. Sanders. But if I just look at the numbers and I see, total company 1 and then the 0.45 in P&M retail, I guess I would understand it in that way. But again, I'm not.
Okay.
I think that's more of a question for Mr. Sanders and how these jurisdictional allocators are prepared.
Okay, but the cost model does include these numbers, and it does use these numbers to generate the total test year revenue requirements for the company, right?
Yes, the cost model is using these jurisdictional allocators.
Okay.
And that could be seen again in the functionalization tab where it's breaking it out. And after it's broken out to the retail jurisdiction, I use the retail jurisdiction P&M revenue requirement to, begin to functionalize and classify those costs. And then those costs are then going to be allocated to P&M's customer classes.
So that means, what can I derive from that fraction, that approximately 54% of this line item, it should be credited to the PNM's wholesale transmission customers?
Again, more of a question for Mr. Sanders, but my understanding is that he breaks it out between retail and I think it's for wholesale customers. So
yeah,
I think that might be a fair statement. But again, I would more of a question for Mr. Sanders.
But there are no other types of transmission customers, are there, in your understanding? There's either a retail customer on the transmission system or a wholesale FERC customer, FERC regulated customer. Is that your understanding?
Yeah, when we're, when I'm developing PNM's total retail non-fuel revenue requirement, I'm only looking at the retail jurisdiction that Mr. Sanders provides to me.
Okay. We'd asked another witness questions about what's called the OATT, commonly called the OAT, which I understand to mean the Open Access Transmission Tariff. Do you understand that acronym in the same way?
I've heard of it, yes.
And if you know, is the OATT the transmission tariff that is charged to PNM's wholesale transmission customers?
I don't know.
Okay. Do you know, so this question was referred to you. Who would you refer it to?
Oh,
questions about the OAT tariff.
right. Going back, Mr. Gray, I think, referred to me as the OAT expert. I think my colleague might have misspoke. I'm not the OAT expert. I'm not too sure who would be the best witness to answer that question.
Well, let me ask you a question. Okay, finish your answer, please do.
I was
Thank
just
you.
going to say possibly Mr. Sanders. I don't know if he's the expert in the OAT, but he is breaking out PNM's revenue requirement between the different jurisdictions. He might have a better understanding, possibly.
Okay. Going back to your testimony about the ESAs, you have allocated approximately 13.5 million of the ESA cost to transmission, have you not?
The 30%, yeah, that sounds about right.
Yeah. And the basis for that is that these that 30% represents the benefit that these assets under your simulation are providing to the transmission system.
Yeah, my understanding is that the 30% is or 70% was, discharged, 70% of the capacity, and then 30% was held back for ancillary services related to transmission. So yes, that's my understanding.
And today, with the system as it is, without any batteries of any size, I think there's a 0.5 megawatt battery someplace that's a DOE test, but that aside, those ancillary services are currently being provided to the transmission system from PNM's, I'll call them traditional production assets, right?
My understanding is that those assets can provide ancillary services, but again, what the simulation was showing is that 30% was held back for ancillary services related to transmission, and again, at the time, that was our best data available, and that's how we functionalized and classified the transmission portion of ESAs.
Yeah, and I apologize. My question was not clear. I'm not talking about the simulation. I'm talking about the system that we currently have, PNM currently has without batteries, is currently providing the production system is currently providing all the ancillary services that the transmission system needs to be stable, viable, and to do its job, right?
Yes, I'm not too sure. My understanding is that they do provide ancillary services. I don't know if it's, yeah, my high level understanding is that they do provide ancillary services.
And if you can say, and I know we're getting into areas where you don't have detailed knowledge, but wouldn't it be true that if the current production assets were not providing ancillary services such as VAR support and quick start, black start support, all those other ancillary services, the transmission system would be failing, right?
I'm not too sure on that question.
Well, let me ask it this way. The transmission system needs something to provide, say, for instance, VAR support. You don't want voltage to drop so low that the motors that are on the system are going to burn up. So you need VAR support, right?
I mean, I would think that if there's no ancillary services provided, that would definitely hinder the transmission system. But that's as far as my knowledge goes. As far as that, I don't get too deep in the weeds with that part. Yeah.
That's an honest answer. Thank you. Let me just ask you a couple more questions about the OAT, and then we can move on. PNM only has one transmission system, right? And it's used by both wholesale and retail customers, right? You don't have two separate systems. Is that a fair statement?
It's my understanding, yes.
So if a benefit is provided to the transmission system by any asset, that benefit is shared by all customers that use the transmission system, right?
May you repeat your question, Mr. Gould?
Yes, if a benefit is provided to the transmission system, let's say from the ESAs, all customers that use the transmission system receive that benefit, correct?
Yeah, I mean, if our customers are all, they're using the transmission system, there's a benefit on our transmission system, I would think they would benefit from it.
So do you know whether any of the 13.5 million that you have stated is a benefit to the transmission system is being charged to the wholesale FERC customers through the OAT tariff?
Again, I'm only, the 45 million of ESA costs. I believe that's the retail jurisdiction portion of ESAs. So again, when I run, Mr. Sanders's revenue requirement through the cost model, I'm only looking at the retail jurisdiction, and this is what came out in his model under the retail jurisdiction. Was the 45 million, the total, and then I use that to, I apply the 67% production demand, and then I apply the 30% transmission demand, and then the 3% distribution demand classifications to that retail portion.
Well, let me go back to your prior answer, or maybe the first part of this answer. My understanding, and tell me if I'm wrong and show me where in your cost model that this would occur. My understanding that the 45 million was the entire cost on an annual basis of the energy storage agreements. Are you saying that there's another cost that's been allocated to FERC?
No, and I could point you, let me point you to the.
Well, let me answer my question first. Is the 45 million the total cost of those ESAs on let me say it better. Is the 45 million the total revenue requirement for all the ESAs that are expected to be providing service in the test year?
Objection Foundation. I mean, Mr. Casas has testified that when he gets his numbers from Mr. Sanders, Mr. Sanders has broken out in wholesale and retail. So this is really a question for Mr. Sanders.
Sustained.
Well, I asked Mr. Sanders if he could go through the page 201 and tell me if those numbers are accurate. He said he didn't produce any of those numbers. And I'm just, Mr. Herrington, I don't want to beat a dead horse, but Mr. Casas seemed to say that there were some additional ESA costs that weren't in that retail number. And if there's a way I can get an answer to that, that would be sufficient to kind of go forward if that's
Ask
okay.
that question.
Okay, is there a place in that you know about in the cost model AC3 that shows that there are additional revenue requirements associated with the ESAs over and above the 45 million that's assigned to retail?
So if you go to in my so P&M Exhibit 43, which is my direct testimony.
Yes, I'm there.
If you go to PDF page 218.
Okay, let me get there, please. What is the number at the top of the page? Could you tell me that?
We were on that page already, just a little bit earlier in this cross.
Yeah, and I apologize. Was that page 15 of 36?
13 of 36.
You're there, Mr. Gould.
Okay, 13 of 30. Okay, so which number are we talking about, Mr. Casas?
So, and maybe I wasn't clear earlier. You know, I didn't mean, if I did say, I didn't mean to say that that there was more, you know, there was cost associated with FERC wholesale customers related to ESAs, because there isn't. And if you look on page 5, I'm sorry, line number 5, where it says energy storage agreement demand.
Yeah.
And then to the right, under the total company column, you'll see the 45,172,557.
Yes.
So 100% of that is going into the P&M retail jurisdiction. And I'm using that 45,172,557 in within the cost model, and that total value, that's this, you know, the 67% production or production demand is applied to that 45 million. The 30% transmission demand related to ESAs is applied to that 45 million. And then the 3% related to distribution demand is applied to that 45 million. So there's no 100% of the 45 million of ESA costs is retail jurisdiction.
Okay, so I think that's the answer to my question. None of the revenue requirement in the test year is for the ESAs. None of it is being assigned to the wholesale transmission customers.
Correct, yes.
Okay.
So in other words, Mr. Casas, that total company number of 45,172,557, 67% of that total company figure is the production demand of 30,265,613.
Correct. So that,
yes,
you have that correct. And I just want to say that column with the P&M retail labeled P&M retail, that's so for all the cost items that are going to be in this exhibit, that P&M retail column is what we use to functionalize and classify. The total company, that value could be, you know, tied to Mr. Sanders's KTS3 model. He'll have total company P&M revenue requirement, and I'm just showing how it's broken out between total company and retail. But the P&M retail column is what we use for for designing rates.
Okay, good clarification. Thank you, sir.
Yes.
I want to move on to a new topic, and that is we're going to get in the weeds a little bit. And that is the CSUT EXP allocator. Are you familiar with the disagreement that Anna Maria has with you about that allocator?
I am familiar.
Okay.
Say that, name it, say that allocators again, because I don't think we have it quite clear yet.
Yeah, it
CU
is CUST EXP allocator.
Okay, thank you.
I don't know how to pronounce it. What do you call it? Custom
What does it, what does it stand for?
Customer expense allocator.
Okay. And embedded within that allocator, it's actually kind of a modified allocator. It assigns, of those customer costs, it assigns 80% based upon customer counts and 20% based on the energy the customer uses. Is that a fair summary?
So yes, that the customer expense allocator is derived on an 80-20 split. And so it's going to be 80% of customer counts, like you said earlier, and then 20% of energy.
And this is the first time that is in your recollection, if you know. Got something going on. Am I still connected?
Everything sounds fine on our end.
I just had some weird noises from my computer. Okay, I'm good. So as far as you know, this is the first time that this particular allocator has actually been explicitly litigated, right?
As far as I know, yes.
Yeah, it was, there are a lot of allocators within the cost model and in the e-cost model before that. So this is the first time that this has been an actual issue in a case, as far as you know, right?
Correct. The first time it's been contested.
Yeah. And Anna Mary, without getting into a huge discussion about it, Anna Mary's position is that these are customer costs. They don't vary with the amount of energy that a customer uses. So they should be allocated on 100% customer count basis. Is that your understanding of Mr. Andrews' testimony?
That's my understanding, yes.
Yeah. What I wanted to do is, could you have your attorney show you Anna Maria cross-examination exhibit number 46?
I'm not in the same room with Mr. Casas, but he should
Okay.
have, I think he's got a copy there.
Would you- And Kelly, would you scroll through that and make sure we have the latest one? I want to see the next page, please. Yes, this is the correct one. Okay, Mr. Casas, what you have before you on, go to page 2, Ms. Gould, if you would, is interrogatory Anna Maria 18.3. Do you see that?
I see that, yes.
And I'm only interested in a part of this answer, so I'm going to read it into the record. It says, please refer to rebuttal testimony of Abraham Casas, page 5, P&M table AC1 rebuttal. Do you see that?
I see that, yes.
And subsection D says, please provide a version of table AC1 rebuttal that demonstrates the overall change in the allocation of P&M's total revenue requirement due to the change of the CUST EXP allocation from 80-20 customer energy split to the 100-0 split. Do you see that?
I see that, yes.
And would you go to the next page, Ms. Gould? And would you go down to the last page of this exhibit, the last page? You have sponsored this response, have you not?
Yes.
Okay, go back up 2 pages if you would, Ms. Gould. Okay, would you read that response into the record for us, please?
To address the subparts below, I note the following as means of context. In my rebuttal testimony at page 5-6, I separately identified 6 of the 8 categories of cost allocated by the customer expense allocator, which were number 1, supervision customer accounts, number 2, customer service / informational expenses, number 3, customer assistance expenses, number 4, informational / instructional advertising expenses, number 5, demonstrating and selling expenses excluding production, and number 6, demonstrating and selling expenses production. I did not separately identify 2 categories, which were number 7, customer service and informational dash labor, and number 8, sales labor, but costs associated with with those categories are already subsumed in the 8.13 million represented by the 6 categories addressed directly in my rebuttal testimony.
Okay. And then in subsection D, you answer that NM area table 18.3D illustrates how changing the CUST EXP allocator from 80-20 split to 100-0 split will shift total non-fuel revenue requirement dollars amongst all customer classes. Specifically, it shows a decrease in total non-fuel revenue requirement for all customer classes except for the residential customer class. The residential customer class shows an increase of roughly 3.4 million in total non-fuel revenue requirement. Did I read that correctly?
Yes, you did.
And would you briefly look at your NM area table 18-3D and take your time and affirm for me that this table is accurate to the best of your knowledge today?
Yeah, that table looks accurate to me.
Mr. Hearing Examiner, I would like to move NM area cross-examination exhibit 46 into the record.
Any objection?
No objection.
NM area cross-examination exhibit 46 is admitted.
Mr. Casas, just kind of going back a little bit to the SERVM model. This is the first case in which PNM has used the SERVM model to allocate and functionalize costs, isn't it?
From my understanding, yes, this is the first time we've used the SERVM model to guide us in our, the way we functionalize and classify an asset. Yes.
Is the SERVM model, and then it's the first case in which you've used the COST model.
Correct.
Are the 2 models linked together?
No, they are not.
Do they have the same constraints? Or limitations?
I'm not sure. I'm not familiar with the SERVM model. I wouldn't know.
Well, let me just state it. The SERVM model is, if you understand, if you can answer my question, is a model that's used to take various portfolios and analyze them under a number of different scenarios to see how the system would operate with that portfolio on a going forward basis. Is that your general understanding of what SERVM does?
Objection, Foundation. I think we've been through that. These questions are, Mr. Casas is sponsoring the output of the model. He is not the expert on the model.
I understand. I'm just trying to find out if there's a link between the 2. Either an actual link or a theoretical link. If you know.
No, again, the only output that we need from the SERVM model are those, the output show that it's a multifunctional asset production, transmission, distribution. So we know where in the cost model, what functional buckets we're going to assign cost to. And then the other output we need would be the classification percentages, which is that 70-30 split, well, 67% production demand, 30% transmission demand, and then the 3% distribution demand. So really, there's no link. You don't need to have a link between the cost model and SERV-M model, but we do need to know, what functional buckets we're going to assign cost to in order to develop, the functional and classification allocator.
What was the SERV-M model, if used to model any of the other production assets and how they operate on the system?
I don't know.
Okay. And my understanding is that Mr. Phillips used a simulation based on his simulation was based in 2025.
My understanding is, yes, he looked at a 2025 calendar year 2025 for his simulation. Yes.
And then I understood from Ms. Chan that he had made assurances to her that that 2024 would absolutely replicate his 2025. I'm not sure if I'm saying it right, but the test year would be consistent with his 2025 results. Did he ever say that to you?
Yeah, my understanding from Mr. Phillips is that the 2025 year test year that he uses in his simulation, that there's no additional resources coming online. So it's a comparable year to our test period of 2024.
Did he address any of the loads, the sales, the weather? Did he address any of those factors?
I think that's a question for Mr. Phillips.
Did he give you any data to support his statement that the 2 years were exactly similar?
That I recall? No, I don't recall seeing any.
Do you know? Okay.
Sorry.
No. You don't apologize to me. I apologize to you when I step on your answer. Why don't you finish your answer? Thank you.
No, I was just saying I don't recall seeing any data or workbook that showed that.
And they're not in, none of that data is in any of the rate schedules that were filed with this application, were they?
No,
none of that.
I don't believe so.
And do you know anybody else besides any other testimony in the initial filing that would address those issues I was just asking you about the SERV-M data being in the system? I mean, being in the application?
I'm sorry, do I know if any other testimony includes that?
Yeah. Any other testimony or schedule where that information would be?
No, I wouldn't know.
So the first time we saw that information would have been the rebuttal testimony that Mr. Phillips filed just at the end of August, I think so, right? Or whenever he filed it.
Yeah, my understanding is, yes, that would be the first time interveners, saw that information related to the simulation.
Mr. Higgins, my time's run out. Can I just make a correction to that? His testimony wasn't filed end of August. It was filed July 28th, Mr. Phillips' testimony. And with that, I'm done with my time. And Mr. Casas, thank you for your patience. And I appreciate your answers and your honesty and your straightforwardness. Let's move. Thank you.
Thank you, Mr. Gould.
As does the commission, Mr. Casas. We're moving on now to the Water Authority. Mr. Herman, I have you down for 25 minutes.
I think I just have 15 minutes.
All right, do you want me to put the timer on 15? It's up to you.
Put it on 15. I'm not going to use all of it as it is. I just have a very short line of questions for Mr. Casas.
Okay.
Good afternoon, Mr. Casas. How are you today?
Doing well, Mr. Herman. How you doing?
Well, I'm Keith Herman. I'm here representing the Albuquerque Bernalillo County Water Utility Authority. And I just wanted to ask you some quick questions about my cross-examination of Ms. Chan. Were you present or watching the hearing for that?
I believe I watched most of it. I was going in and out at times, so I might have missed a few pieces of it.
She was on for a while. I won't hold that against you. You have access to ABCWA Exhibit 3, the corrected direct testimony of Andrew Harriger.
Yeah, let me get it real quick. Okay, I have it.
If you go to towards the end, ABCWA Exhibit AKH 8.
What was the name of the exhibit again, Mr. Herman? Sorry.
AKH is in Andrew. I don't know Andy's middle name, Harriger. Exhibit 8.
Me. We're working on getting that. Sorry.
If you have the electronic version, it would be page 1, PDF page 122. And Mr.
Speeding
Herring's-
things up. Yeah.
Mr. Herringzimmer has put that on the screen share. Mr. Herringzimmer, could you go to page 2, please? Do you see that, Mr. Casas?
I'm gonna try to bring it up online. Sorry.
The Herringzimmer has it on screen share right
Oh,
now.
okay. Yeah, I see it.
So that's interrogatory ABCWA 6-11, correct?
Correct. Yes.
And you sponsored that response, correct?
Correct. Yes.
Now, I just want to ask you about the third column in that table. Would it be safe to assume that all of those times in that third column are in MST or Mountain Standard Time?
So, okay, so the column labeled system peak date time.
Yes.
Yes, my understanding from our forecasting group when we received the forecast is that that was in Mountain Standard Time.
And did you see my exchange with Ms. Chan about the difference between Mountain Standard Time and Mountain Daylight Time?
I think I do recall that, yes.
And it would be correct to say that Mountain Standard Time doesn't change throughout the year, whereas Mountain Daylight Time does change for daylight savings time.
Can you repeat that again, Mr. Herman?
Mountain Standard Time is clock time, I'm sorry, Mountain Standard Time is the same throughout the year, correct?
Right.
And Mountain Daylight Time is the one that's adjusted for daylight savings time.
Yes.
Okay, so again, another way to refer to Mountain Daylight Time would be clock time.
Yeah, so my understanding would be, I guess, Mountain Prevailing, would that be? Yeah, I guess that would be clock time, yes. Sorry.
I'm sorry for this line of questioning, but it was just something I wanted to just clarify, because that third column didn't have a MST designation, so I wanted to make sure we got that Right. If I had some questions about PNM's time of use proposal, would you be a good witness for that?
I believe Dr. Pitts would be a better witness for the time of day proposal.
Okay. I was just going to, never mind. I'll save that for Mrs. Pitts. That's all I have, Mr. Examiner.
Thank you, Mr. Herman.
Thank you, Mr. Casas. Thank you, Mr. Examiner.
Thank you.
Of course. We have WRA up next. Ms. Beatles?
Yes, thank you, Mr. Hearing Examiner.
Sure. I have you down for 20 minutes.
Yeah, can we take the screen share off, please?
Sorry.
Thank you.
Okay, please proceed.
Good afternoon, Mr. Casas.
Good afternoon.
I'm Sydney Beatles and I represent Western Resource Advocates. How are you?
Doing well. How are you doing?
Fine, thank you. So, Mr. Casas, in your direct testimony on the last page, page 24, line 2, you refer to the NARUC manual, right?
Correct, yes.
And specifically, are you referring to the 1992 cost allocation manual that's cited on page 13 of that same direct testimony?
I believe so. I think the 1992 is the latest and greatest version of the NARUC manual. So yes.
Has it not been edited since?
To my understanding, it hasn't.
Did you review it when you were at New Mexico State, or did you first study it when you started working for PNM?
I did become familiar with the manual back at state, but I didn't actually begin to really, look into it and up until I came on board with PNM. And reason being is just like, going through PNM's previous rate cases and trying to understand the e-cost model and the allocation methodologies that were being used. I thought it'd be a good idea to, read some of the NARUC manual.
So referring back to page 24 of your direct testimony, line 2, you refer to, and continuing on to line 3, you refer to the MDS methodology.
I see that.
MDS stands for minimum distribution system, right?
Correct.
Is that a method of classifying distribution cost for purposes of designing rates?
Yeah, so in the NARUC manual, it does discuss, so there's two MDS methods. There is a minimum size method and there is a zero intercept method. And both of those are discussed within the NARUC manual. And yes, to your question, it is a methodology that can be used by a utility to allocate their distribution demand costs.
And does the manual contain other methods of classifying distribution cost?
Trying to remember. It does mention, that distribution cost should be allocated on a non-coincident peak methodology, so the NCP methodology. And then, I think after it talks about that, it goes into the MDS method. And but if I recall, I think it just focuses on the MDS method, the NARUC manual.
Are there other methods in your field that aren't identified or discussed in the manual that are used to classify distribution cost?
Yeah, so again, the way I think of the NARUC manual is just kind of a guide. It's gonna have, it's gonna have what it has in that manual. That's not to say that that's the only, that those methodologies are set in stone. There's other literature out there, such as Bonbright, who I know is critical of the MDS method. So it's just really, it's a matter of opinion on the methodologies, and MDS is just one of many methodologies that a utility can use to allocate their costs, their distribution costs.
Would you say that reasonable minds can disagree?
Yes.
And I have one more question, because let me get to the page. So I'm confused between pages 20 and 21 of your direct testimony, because on lines 7 and 8 of page 21, you say it is impractical to propose an MDS methodology at this time. But on page 21, line 21, you state that the MDS methodology that PNM used was the minimum intercept cost of facilities. So I'm confused as to whether you, on one hand, you say it's impractical to propose it at this time, but then on the page 21, you say you use the minimum intercept version of the MDS methodology. So could you please reconcile those two statements?
Yeah, so, the reason so on page 21 of my direct testimony, line 21, I do state that PNM used the minimum intercept methodology, and we're not proposing, so we showed an MDS study, but we're not using that in designing our rates. I think from the 2015 rate case, the final order, there was an order stating that PNM should look into either one of the MDS methods to look into the data, gather the data, and provide a study. And that's what we did. We provided an MDS study, but we're not incorporating it into our rate design. So that output from the cost model with MDS applicable is not being used in our current rate design proposal.
So for purposes of compliance with that past commission order, you use the minimum intercept version of the MDS methodology in that study. Is that your compliance study? Is that right?
Correct. We're using and I think I refer to it as zero intercept, but yes, the zero intercept MDS method is what's shown in my direct testimony.
Okay, that clears it up. Thank you very much, Mr. Casas. And that's all I have, Mr. Hearing Examiner.
Thank you.
Thank you, Ms. Beatles. Sorry. Thank you, Ms. Beatles. Right, staff. I believe we have Ms. Regensburg. We have you down for 15 minutes. Is that correct?
Yes, sir. That's correct. Thank you very much.
Please
Good
proceed.
afternoon. Oh, sorry. Good afternoon, Mr. Casas. My name is Gloria Regensburg. I work for Public Regulation Commission in the Legal Division, and I'm here representing the PRC staff this afternoon. So I'd first like to take you back to I have some questions regarding your conversation with Mr. Gould a little bit earlier. Do you recall the conversation you had with him on the simulation or the SERVM model?
Yes.
Okay. And so were you the person responsible for the development of the model? Or
No, so PNM witness, Mr. Phillips,
Okay.
is the one who ran the model. He ran
Okay.
that simulation. Yes.
Great, thank you. And did you go over the survey model that calculated the modified 3 summer, 1 winter coincident peak demand allocator in detail with Mr. Phillips prior to the time of the filing of P&M's application?
Again, what I went over with Mr. Phillips was just the output. And when I say output, just,
Okay.
the functional categories that the battery storage asset would be benefiting, and the classification percentages.
Okay. So you're not the witness then that's supposed to file direct testimony on behalf of PNM, reviewing, approving, and testifying to the results of the model?
No, that would be Mr. Phillips.
Okay. All right. So the next thing I'd like to do is take you to PN Exhibit 43, which is your direct testimony pages, page 6. And the lines 14 through 15.
Okay.
Okay. And would you mind just reading those 2 lines, please?
And I'm sorry, did you say the PDF page 6 or my?
Oh, it's actually the page 6 of the testimony, not PDF page.
Okay,
Sorry.
gotcha.
Sorry about that.
And what lines did you want me to read again?
14 and 15, please.
14 and 15. Okay. The final step is allocation. Functionalized costs are allocated to customer classes based upon criteria that fairly reflects each class's responsibility for the cost, i.e. cost causation.
Okay. And does that statement reflect or indicate that you allocated costs among customer classes using methods that reflect what caused those costs to be incurred?
Yes, that's what that
Okay, great, thanks.
saying, yes.
And now if we would go to the rebuttal testimony of Dr. Pitts, it's PNM Exhibit 48, please.
Let me just pull that up.
Okay.
Okay, and what page?
And page 35, and just lines 12 through 18. She's answering the question, please discuss the difference between gross load and net load. Do you see that?
Page 35, lines.
12 through 18.
Yes, okay, I see that.
Okay, and she's answering the question there on 12 and 13. Would you read the response starting on line 14, please?
Yes, so gross load is the entire load regardless of which generation resource is producing energy. Net load is the gross load minus the renewable resource load, so that what remains is the load that is served by traditional generation. Excuse me. These generation resources can be scaled back to accommodate the must-take renewable resources such as solar and wind.
Okay, great. Now we're gonna go ahead and jump to Staff Exhibit 2, which is PNM's responses to staff interrogatories, or Discovery Request 8, I believe.
Staff Exhibit 2, okay.
Mm-hmm. And we're going to go to page, I think it's 16 of 18.
16.
And so question 8-26, staff 826 on page 16 of 18.
Okay.
Would you go ahead and just read the response, please? Or actually read the question and the response, please.
Okay, so 8-26, the question is, refer to Pitt's rebuttal 3512-18. In PNM's proposed production and transmission demand allocators.
I'm sorry, 3512.18 and
In PNM's proposed production and transmission demand allocators, did PNM use the system coincident peak gross load or the system coincident peak net loads? And the response is, in PNM's proposed production and transmission demand allocators, PNM used the system coincident peak gross loads.
Do you agree with that statement? In the response?
Objection, Foundation. I mean, this is Dr. Pitts's response to discovery. It refers to her rebuttal. She's up next. I think staff can ask this question for Dr. Pitts.
I'm just asking if he agrees to the response. It refers to allocators.
Well, we haven't laid a foundation here in Examiner that Mr. Casas is familiar with this response and he knows the piece of testimony, that he understands the context of the testimony we're referring to.
Lay the proper foundation, Ms. Regensburg, please,
Okay.
and I'll allow.
Are you
Allow
familiar with the rebuttal question that you just reviewed? Dr. Pitt's testimony or in her rebuttal?
I would have to go back and look. I don't know Mrs. or Dr. Pitts's rebuttal testimony too well by memory.
Okay. Did you talk to her about before you wrote your direct, or did you talk with her about the allocators at all before you wrote your direct testimony or rebuttal, or while she was drafting?
Yeah, I mean, when we work through this, we are communicating with each other. So I would say, I think, Dr. Pitts, I'm sure at some point we talked about the allocations that I was using in my cost model.
Okay. Can you agree with the statement based on that, or you can just say yes or no?
I think we could have been, maybe PNM could have been more clear on this response, just, talking about the modified hours that we used. Maybe we could have dropped the mention of that in the response.
Okay, thank you. We'll just go on to the next question. Do you agree that PNM used coincident peak gross loads to develop its modified 3 summer, 1 winter, 4 coincident peak allocator that it used to generate? Let me start over, sorry. Do you agree that PNM used system coincident peak gross loads to develop its modified 3 summer, 1 winter, 4 system peak allocator? And also, oh, go ahead.
No, I was just going to say no. Again, as I talked with Mr. Gould, the modified 3 summer, 1 winter allocator is using, what I call the storage dispatch peak hour, which is different than our system peak hour. So the CP demands related to the customer classes at the storage peak hour is going to be different than their CP demands at the system peak hour.
Did it apply that allocator to allocate generation demand and transmission costs?
The only modified allocator that we have is the modified 3 summer, 1 winter that's being used for the production demand related costs to ESAs. Other than that, there's no, that the allocator is not being used anywhere else.
Okay. And when you're talking about the ESAs, that's the battery storage?
Yes, the energy storage agreements of battery storage.
Energy storage agreements. Okay. Is your testimony that the modified 3 summer, 1 winter coincident peak allocator reflects cost causation for generation demand and transmission demand costs?
My testimony is, you know, as the utility, we try our best to line up, you know, cost allocation with cost causation. And given that, you know, based on the simulation, these storage assets were gonna be utilized at a different hour. We felt it appropriate to develop this modified 3 summer, 1 winter allocator, but we only used it for the production demand costs related to ESAs. Everything else is still on our unmodified 3 summer, 1 winter hour, which is looking at the CP demands at the system peak hour.
Okay. Okay. Let me see. All right, I think I have a couple more questions. Let's go ahead and take a look at PNM Exhibit 43. That's your direct testimony pages on page 7, please.
Okay.
And looking at lines 4 through 13.
I see that, yes.
Okay. And does the 3 summer, 1 winter coincident peak allocation satisfy all 3 of the listed criteria for allocating production and transmission capacity related costs that's described in your?
So you're asking if the unmodified 3 summer, 1 winter, right?
Yes.
Okay. Yes. So if you turn to, sorry, let me find it. It's in my direct. So if you turn to page 10 of my direct, you'll see PNM figure AC-1. And so what this is showing is just the average system peaks from July 2017 to June 2022. And, you know, you could see that on PNM system, we're still experiencing two seasonal peaks. You could see June, July, August, so the summer peak. And then if you look at December, we have a winter peak. So right now, you know, currently, you know, it's going to change going forward with more renewables coming on board. But currently the unmodified 3 summer, 1 winter is still an appropriate allocator because again, PNM is still experiencing these 2 seasonal peaks. You have the 3 summer months and the 1 winter month.
Okay. Great. Thank you.
Mm-hmm.
All right. If customers or customer classes shift their loads onto PNM's summer or winter system coincident peak loads, would it increase the allocated cost to serve the customer or customer classes?
Yeah, you know, if customers are using, you know, more, if they're using more during the system peak hours, those demands would be greater when developing these allocators, and therefore it would allocate more cost to the class.
Okay. Is that my time?
Yes, it is.
Would it be possible? Let me take like 5 minutes from Mr. Phillips?
Yes.
I just have one more question or a couple of minutes. I don't think I need more than that.
Okay, go ahead.
Thank you. At this time, I have, oh, actually, I think that was my last question. Sorry, I just wanted, I wanted to, well, thank you very much for answering my questions and also ask the hearing examiner if we can admit staff's Exhibit 2 interrogatory 826. I understand we'll have to revise the exhibit to submit the cover page with the interrogatory and the affirmation. Is that
subject to making the revision.
Mhm.
I would PNM object to the admission of staff Exhibit 2.
I mean, I'm going to object. I mean, Mr. Casas tried his best to answer it, but he said he wasn't super familiar with Dr. Pitts' testimony. So I'm going to object.
All right, well, it's fine. We'll go ahead and,
Withdraw.
yes, that's fine.
Okay. With the submission of staff Exhibit 2 withdrawn, and that's the end of staff's cross-examination. Hearing
Yes.
Examiner Ryan, thank you,
Yeah,
Mr. Rickensburg.
I'll be quick.
Hearings
Thank you, Ms. Maderas. Yeah. So Mr. Casas, page 16 of your direct, and I've listened to Mr. Gould hammer away at this point, so I'm going to try to get some clarity in my mind. At the top there, beginning at line 1 through 7, to
Okay.
determine the split between production and transmission, PNM analyzed the amount of energy storage actually dispatched in the peak storage dispatch hours relative to what could have been dispatched, but was held back for ancillary services. PNM found approximately 30% of potential energy storage output was withheld and contributed to ancillary services related to transmission. Thus, 30% of energy storage costs were distributed using a transmission allocator. What are the ancillary services?
I think that's a better question for Mr. Phillips, but my understanding of ancillary services are, services that help that help, I guess, moderate and stabilize the system. It's my general understanding of ancillary services.
Okay, so just so I understand what you're saying here at this paragraph or at this section, when you say PNM found, should I interpret these sentences to mean that Mr. Phillips found for PNM and informed you that this is what's happening?
Right. So with the simulation, the output of the simulation is that 70% of the capacity of those batteries was discharged, and 30% of that, which is what you just read here, was held back, and it was held back for ancillary services related to transmission, and that's why we classify 30% of the ESA costs of the 45 million to the transmission demand bucket, and then the 70% that I just mentioned, and I think I might have mentioned this with Mr. Gould, but we took 3%, and it was kind of a placeholder for that we use for distribution demand. I don't think the simulation models down to the distribution level. So we just took 3%, 1% for distribution demand substation, 1% for distribution demand primary, and then 1% for distribution demand secondary. And then the 67% that remained is going into or being classified as production demand.
Okay, so, but just for clarification, can you identify one ancillary service that the batteries perform that justify allocating it this way?
Off the top of my head, sorry, no.
Thank you. No further questions for me, Mr. Maderos.
Thank you, hearing examiner Ryan. Redirect, Mr.
Yeah.
Williger.
Thank you. I'm going to work backwards from the questions here, Mr. Costas. The simulation you were just going over with Mr. Hearing Examiner Ryan. You've discussed that in your direct testimony. Is that right?
That's correct. Yes.
And you fielded several questions about the simulation at deposition.
I'm sorry.
Did you field several questions about the simulation at your deposition with Mr. Gould?
Yes.
Okay. And can you tell me kind of how you explain that simulation, just generally at a high level, or can you tell me how you explain that simulation at the deposition with Mr. Gould?
Yeah. Again, my understanding at the deposition when I explained it was that the simulation that Mr. Phillips ran, the output of that was that these batteries, they could discharge their full capacity, but the simulation showed that 70% was discharged and 30% was held back for ancillary services related to transmission. And then the 3% that we're using for distribution demand components is a placeholder, because from my understanding from Mr. Phillips is that the simulation does not go down to the distribution level.
Okay, thanks, Mr. Costas. I'm going to share my screen if I can, hearing examiners, real quickly. Is that
Sure.
possible? Thank you. You see that, Mr. Costas? The request for production 6-1.
Yes, I see that.
And I know this is sponsored by Mr. Phillips. Do you have any familiarity with that response at all? Or do you recall it? If you can read it, maybe.
Mr. Hearing Examiner, I'm going to object. This obviously is not sponsored by this witness. And this is not stuff that he evidenced any familiarity with.
Maybe I could try to set up the question better. And I'm sorry, I'm just trying to get through them faster. But if I set up the question better, hearing examiner, maybe that will lay the foundation for why I'm asking this question. Is that
Please
great?
do.
Thank you. You recall, Mr. Costas, you were asked by Mr. Gould if rebuttal was the first place.
I'm not hearing anything, but is my sound muted online?
No, you're not muted, Mr. Gould. Let Ms. Terwilliger set up her foundation, please.
I don't think he can hear us.
Yeah, I think he's without audio.
Okay. I will put back on my headset. Sorry about that.
So
I apologize. I got a phone call and I'm sorry.
That'll help a little bit.
Disregarded it. Yeah, we're going to object to this witness answering
I
anything
heard
about this
Ms. Terwilliger was going to try and lay a foundation.
particular discovery response.
I'm going to allow her to lay a foundation, Mr. Gould.
And Mr. Hearing Examiner, I'm not hearing you, and I do apologize. This is I am multiplying my technical errors. There we go.
I believe the transcripts. I think Mr. Lee's hearing you. So
Okay, thank you.
okay, so Mr. Casas, do you recall you got questions for Mr. Gould about whether rebuttal was the first time that the interveners would have seen the results of the simulation? Do you recall that question?
Yes, I do.
And do you recall this discovery response where Mr. Phillips perhaps provided the output of that model?
I do recall this discovery response. Yes.
Okay. So is it the case between your deposition and this discovery response that rebuttal maybe wasn't the first time that interveners saw the results of the simulation or were told about the simulation?
That is the case. Yes.
Okay, I'll stop sharing. Thank you. All right. The customer expense allocator, Mr. Casas, can you kind of tell me in your own words, let me set up the question. You recall the questions from Mr. Gould about the customer expense allocator, and we admitted a response that shows assigning that entirely to customer counts, having that customer expense allocator be entirely to customer counts. Do you recall that?
I do recall that, yes.
So can you tell me in your own words why it's appropriate to allocate cost based on an 80-20 split, 80 being customer counts and 20% being energy?
Yeah, so, again, with cost allocation, there's not an exact science tied to it. Sometimes you have to put in some judgment of, fairness. And with the customer expense allocator, and I think I talked about the individual accounts where it's being used. There's certain accounts, there's certain accounts that are being allocated on a customer expense that it makes sense to use 80-20. And one of those accounts is the customer assistance expense, which is $815,663. And these costs are related to account management. And if we were to change the customer expense allocator from an 80-20 to 100% customer accounts, some of PNM's largest customers, such as 36B, 30B, 15B, who are managed, would be allocated $1 out of the 815,000 related to account management. And again, another account is the demo and selling expenses, which is related to wholesale power marketing activities and PNM's participation with EIM. And those costs are, roughly 7.5 million. And again, if you change the 80-20 split to 100% customer account, those customer classes that I just mentioned, the large customer classes, would be allocated $14 of those costs. And to me, it's, the benefits that the customer class realized from participation in EIM and wholesale power marketing, those benefits flow through, the fuel clause. And I just find it hard to believe for, 36B, 30B, 15B to be allocated $14 out of the total cost bucket related to EIM and wholesale power marketing. So it's just, we need to take into account, and I don't know if other utilities have this, but PNM has, some classes with one customer, and there's certain costs that allocating based on customer count does not seem fair to the other classes, and which is why we have an 80-20 split to kind of account for that.
Okay. One more question for you, Mr. Casas. Do you run the cost of service model?
Mr. Sanders' cost of service model? No.
Yes. Do you actually go to the cost of service model and verify the accuracy of that model?
No, Mr. Sanders is the expert on that model, and I don't go in and do a quality control on his output.
But you take the output of his model, right, into your model?
I do take the output from Mr. Sanders's model, yes.
And you trust that Mr. Sanders is the qualified PNM person to run that model, is that right?
Yes, I do trust that.
Okay, that's all my questions. Hearing examiners, thank you.
Thank you, Ms. Terwilliger. Anything further, Mr. Ryan? Your examiner, Ryan? No. Mr. Casas, I truly appreciate your testimony, your pleasant demeanor, and your patience and your knowledge. Commission greatly appreciates your testimony, sir. Thank you. You are excused.
Thank you.
Although provisionally subject to potential recall as a anchor PNM witness.
Understood.
Thank you, sir. All right, let's take a break. Let's go. Let's go. Could we go for 20 minutes? Would that work for everybody? Yeah. We'll come back at 3:45 with Dr. Pitts, I believe. Is that right, Ms. Terwilliger?
That is correct.
Thank you. We are in recess until 3:45. Thank you all.
Mr. Hearing Examiner, doesn't look like we're going to get to Mr. Phillips today, does it?
No,
Okay, thank you. Appreciate that.
thank you.
You bet.
Oh,
So we're going to be in recess till 3:45. Another 5 more minutes.
Thank you.
Yep.
Hey, I think we're back from our afternoon break on this 8th day of rate case hearings. PNM, would you please call your next witness?
Good afternoon. PNM calls Dr. Pitts. Can the witness be sworn, please?
Would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter now opinion should be the truth, the whole truth, and nothing but the truth.
Yes.
Thank you, ma'am.
Dr. Pitts, can you state your name, spelling your last name and your title for the record, please?
My name is Heidi M. Pitts. My last name is spelled P as in Paul, I-T-T-S. And my title at PNM is Lead Pricing Analyst.
Thank you. And do you have in front of you what's been marked as PNM Exhibit 45, which is your direct testimony filed on December 5th, 2022?
Yes, I do.
And was that prepared by you or under your direction?
Yes.
And is the exhibit, PNM Exhibit 45, does it reflect the errata that was filed for this testimony?
Let me check. Yes, it does.
Okay, thank you. Are there any other corrections to PNM Exhibit 45?
No, there are none.
And is this testimony true and accurate to the best of your knowledge?
Yes.
And if I asked you those same questions today, would your answers be the same?
Yes.
I move for admission of PNM Exhibit 45, please.
Any objection? Hearing none, PNM Exhibit 45 is admitted.
Do you have in front of you what's been marked as PNM Exhibit 46, which is your January 7th, 2023 supplemental testimony?
Yes.
Was that prepared by you or under your direction?
Yes.
Any corrections to PNM Exhibit 46?
No.
And if I ask, is this testimony true and accurate to the best of your knowledge?
Yes.
And if I asked you the same questions today, would your answers be the same?
Yes.
PNM moves for admission of Dr. Pitts's January 27th, 2023 supplemental testimony.
Any objection to the admission of PNM Exhibit 46? Hearing none, PNM Exhibit 46 is.
Thank you. And Dr. Pitts, do you have in front of you what's been marked as PNM Exhibit 47, which is your February 17th, 2023 supplemental testimony?
Yes.
And was that prepared by you or under your direction?
Yes.
And this is this Exhibit 47 are there any corrections to that exhibit?
No.
Is it true and accurate to the best of your knowledge?
Yes.
If I asked you those same questions today, would your answers be the same?
Yes.
Last one. I think you get the win. You win for the, I'm sorry, I didn't move for admission. Move for admission of PNM Exhibit 47. Sorry.
There any objection to the admission of this exhibit?
Rates will be the same.
Hearing none. PNM Exhibit 47 is admitted.
Okay, one more. Do you have what's been marked as PNM Exhibit 48, which is your rebuttal testimony filed on July 28, 2023?
Yes.
And was Exhibit 48 prepared by you or under your direction?
Yes.
Are there any corrections to PNM Exhibit 48?
No.
Is this testimony true and accurate to the best of your knowledge?
Yes.
If I asked you the same questions today, would your answers be the same?
Yes.
I move for admission of PNM Exhibit 48.
Any objection? Hearing none, PNM Exhibit 48 is admitted.
Okay, with those 4 pieces of testimony marked, I tender Miss Dr. Pitts for cross, please.
Thank you, Mr. Twilliger. First up is the county with Bernalillo County with 10 minutes. Mr. Albright, is that right? 10 minutes?
Yes, sir. That's what I have.
Okay, please proceed.
Thank you, Mr. Hearing Examiner. Good afternoon, Dr. Pitts.
Hello, Mr. Albright. How are you?
Good, good. And by way of reminding you, I'm with J. Albright Law LLC, and I'm here this afternoon on behalf of Bernalillo County. So I would like to, since my time is limited, just to get started mostly on your direct testimony. Could you please turn to page 9 of your direct testimony, where you talk about revenue requirement by customer class?
Yes, sir. I'm there.
Okay, under the question beginning at line 12, and then your response to there, you include 3 inputs with regard to cost causation. Would you define how the customer-related revenue relates to the cost causation?
Well, these are inputs that come from Mr. Casas' cost model, and they are broken out by customer demand and non-fuel energy related. And so the customer related revenue components, the cost components that make up that are like meters, customer service, customer other. Those costs in his model were classified and grouped together and then imported into the rate design model.
Okay, and for the rate design model, is there any way that you have taken into account, besides the direct customer bills that are paid, the fact that they also pay, for example, services for the water utility authority through taxes, or the jail, or community centers, fire stations, police stations? Is there any way for accounting for that in your cost analysis?
No, sir. It's just the revenue requirement based on the cost to serve for those components. But no, the items that you mentioned are not taken into account.
But those would be paid for by consumers as part of their taxes, correct?
That's my understanding. Yeah, the taxes pay for those.
Okay, I want to turn to page 15 as well.
Okay. Okay, I'm there.
Okay, and there you talk about the energy burden, and you state that in general, at line 13, in general, energy burden is a result of significant, higher than average percentage of household income spent on energy bills. Do you see that?
Yes.
Okay, and then you go on to state that a household that spends more than 6% of its annual income on energy bills is considered highly energy burdened. Did I state that correctly?
Yes, that's from my direct testimony.
Okay, and so in the footnotes there, does that 6% apply to New Mexico, or is that a general, looking at the cited source there at the bottom?
It's just a general consensus of what it means to be energy burdened.
Okay, so that's across the US. It's not just limited to what New Mexico is.
Right, and then you can look at a state individually and determine what, you know, the number of households that are energy burdened or that, you know, are in the different buckets of energy income to see how energy burdened they are. Alaska and Hawaii might be done separately just because they're distinct, you know, they have their own federal poverty guidelines and things, but yeah, the 6% is just a general guideline.
Okay. And continuing in that same section there where you have housing energy includes electricity, gas, and other fuels, how does PNM come up with gas and other fuels other than just electricity?
Well, this was from the citation down at the bottom of that page, that table that you're referring to, I believe, on page 16, the table HMP2 comes. It's a tool that was developed by the U.S. Department of Energy and NREL. The acronym, Mr. Lee, is N as in Nancy, R as in Robert, E, L as in Lee, and it's a tool that they've developed. So they have defined these categories. PNM didn't define them. It's just a tool that we can use to examine energy burden in New Mexico.
Okay, and I had a question about that table, HMP2 on page 16. Do we have more recent data than 2018, or is that the best we can do at this point? I mean, that was 6 years ago, almost 6 years ago.
Right. Well, it's from the 2018 American Community Survey, which is, you know, it's one of those tools that the Census Bureau does in between census years. And so results from the American Community Survey typically lag several years. This was the most recent at the time that I filed direct testimony. I haven't looked at it since. It could be that it's updated by a year. It's only been 9 months in between filing the direct testimony and testifying today. So it might be up to 2019, but it might not be. So the American Community Survey is always a little lagged.
Okay, but you haven't checked to see if there's more recent data?
No, sir.
Okay. Let's look at the table HMP 3 on page 19, please.
Yes, sir, I'm there.
Okay, so you go through the different breakdowns with regard to the 1A and then the low income as well, and the usage there. At lines 12 and 13, you state this data influenced how PNM considered its rate design for the residential customer class. Did I quote that correctly?
Yes.
Okay, so the percentage of non-low income customers that you list there, does that reflect, strike that. Let me ask it this way. Would you expect people who install rooftop solar to fall into that non-low income customers?
I think it is more likely that people who install rooftop solar are not low income. So yes.
And do you think that would skew the results overall?
What do you mean?
Well, just with regard to where the blocks are divided between block 1, block 2, and block 3 for the residential classes.
I'm sorry, I still don't totally understand the question. Could you?
All right, haven't done a very good job with that. Let me restate. With regard to rooftop solar, would you expect the electrical use of those consumers to be low or lower than it would be without the solar?
Right. So 90% of PNM's net metered customers have at least 1 month with 0 usage. And so, yes, I mean, they have lower usage because of the presence of their rooftop solar.
And do you think that that should change the apportionment between block 1, block 2, and block 3 with regard to the levels, the 450 or the 450 to 900 or the 901 plus kWh above, 901 plus? Do you think that would skew the data at all? Or would require, related to that, would it require readjustment of those block allocations?
I see. So if I can restate what I think you're asking, it's if we should redo the levels assigned to each block. If block 1 should be, say, up to 600 kWh. That's your question?
Exactly.
No, this is a rate design, the one that we have currently with the block energy usage for residential 1A, that is designed to encourage conservation with the idea that to reduce peak usage, customers should use less. And that's why the rate increases by block. It is a rate design that is not going forward what we are likely to use in the long run, because we're shifting our focus with our pilot time of day program or pilot time of day rate to creating price incentives for when customers use usage, rather than encouraging them to use less. As more and more things are electrified, we're moving to a time of day structure. So no, I don't think that the presence of rooftop solar means that we should increase the block levels for each of these 3 blocks.
You think the
Mr. Albright, we're in added time now. We're past the 10 minutes. We're at the 12th minute now.
With that, Mr. Hearing Examiner, I'll go ahead and conclude my questions of Dr. Pitts. So thank you very much, Dr. Pitts. I appreciate your responses, and we'll just take the added time from Mr. Phillips, Mr. Hearing Examiner.
I won't take that. I won't take the time. I appreciate the approach you took, so I'm not going to take any time away from Mr. Phillips. Thank you, Mr. Albright.
Thank you, sir. And thank you, Dr. Pitts, for your information and insight.
Thank you.
Okay. Right, the Water Authority is up next, I believe, with Mr. Herman. There you are. 10 minutes with Dr. Pitts, is that right?
That is correct.
Okay, please proceed.
Good afternoon, Ms. Pitts. How are you today?
Good. How are you, Mr. Herman?
I'm doing well. I'm Keith Herman. I'm here on behalf of the Water Utility Authority. And since we only have 10 minutes, I'm going to jump right into it. Do you recall either my discussion with Mr. Casas or Ms. Chan regarding ABCWA interrogatory 611?
I was in and out, so I didn't hear all of it.
Well, did you recall, or were you present for the exchange where we discussed the fact that the modified 3 summer, 1 winter peak hours do not include the actual system load peaks?
No, I wasn't present for that.
Okay. I'm going to share that exhibit. Do you see that on your screen?
Now I do.
And
Could
can
you
see-
enlarge it, please?
Let me try. Is that legible?
Yes, sir.
Okay, my screen is cutting off half of it, but that's okay. I have a printout version too.
Yeah. May I ask, Dr. Pitts, is this cutting off? Because it is on my screen as well.
It's cutting off after the column that's system peak date time.
Let me try that again. And if I run over time, I'll move some over on some of my other witnesses. Okay, is this better?
Yes, thank you.
I have one of my monitors in profile mode, which helps with reading documents, but it doesn't always, it did not translate for the screen share. Okay, now, Ms. Pitts, or I'm sorry, Dr. Pitts, excuse me if I misspoke your title earlier.
It's fine.
We had some discussion over the difference between MST versus MDT. Were you around for that?
Yes, I think probably for most of it, but maybe not all of it. Like you were discussing prevailing time and Mountain Standard Time and clock time.
Yeah, I really don't want to belabor this point and add more confusion to that issue, but let's start with December. What time is that on clock time? Excuse me, what are all these times in clock time?
Starting with the one, you want me to interpret all the 3 columns of times? Is that what you're asking me?
Yeah, I started with just December because December, MST, MDT are the same, correct?
I'm sorry, say that again.
In December, there's no difference between MST and MDT, correct?
Correct.
So that 1,800 hours in the modified 3 summer, 1 winter, the first column for December, that would be 6 p.m., correct?
Yes, because it's our beginning, 1800, which is 6 o'clock.
And then 1,900 hours in the next 2 columns, that would be 7 p.m., correct?
In the middle column, yes, because it says our beginning. The system peak date time doesn't say our beginning or our ending, but I would assume that it's our beginning. Like
yeah, and
columns, so.
I tried to clarify that with Mr. Casas as well, but then the remaining times, let's start in the first column. All the peak hour beginnings are at 2,100 hours MST, correct?
Yes.
And in clock time, that would be 10 p.m., correct?
Yes, our beginning 2,200.
And then 1,700 hours in the middle column, that would be 6 p.m., correct?
Yes.
And then 1,600 hours for August in the unmodified time, that would be 5 p.m., correct?
Yes, our beginning 1,700, yes.
I actually have a couple more questions on that. I'm going to apologize in advance, but I just wanted to lay that out.
That's fine.
So do the hours shown in this table for the summer month in the modified 3 summer, 1 winter, the first column, occur within the on-peak periods included in the proposed non-residential TOD time of day pilot rate?
The June, July, and August in the column on the left are all Mountain Standard Time, hour beginning 2100. So Mountain Daylight Time, prevailing time would be hour beginning 2200. And at that point, it is the off-peak period for the commercial time of day time periods. The December one is, as we agreed, Mountain Standard Time and Mountain Daylight Time are the same. So our beginning 1800 is 6 o'clock, and that is within the on-peak period for the commercial and the residential peak period, which is 5 to 8 in the non-summer months.
Okay, thank you for that. And this is going to be the last question I ask, and it might be a little theoretical, so it's okay if we don't have an answer, but with the legislature potentially considering either full-time daylight savings time or, you know, let's say Arizona that doesn't go on daylight savings time, would we need to start revising all of our time of use rates, or would there be an impact of that time change if the legislature were going to take that action?
I guess I want to object because I don't know if Dr. Pitts has any knowledge of a legislative proposal and what the context of that for. I'm not sure you laid that foundation, Mr. Herman.
I'll lay a foundation. Ms. Pitts, are you aware of any legislative pushes that have been discussed to consider going full-time daylight savings time or full-time or getting rid of daylight savings time altogether?
I don't know about any specific proposal in the legislature, but you hear, or I hear about it off and on in the media. So, I mean, I'm aware that nationwide people talk about it, whether it's at the federal level, or I don't know what the state legislature is doing, but I'm aware.
So just in a general sense, if there were going to be a push one way or the other, would we need to start rethinking some of our TOD proposals? Would that have an impact? Considering that the TOD proposals in this application are on clock time?
I don't think we would need to adjust it because they would still be on clock time, whether everything was Mountain Standard Time or there was still daylight savings time, because, say, thinking about we'll use the commercial time of day on peak period, since you represent the Water Authority, 5 to 10 clock time is, or prevailing time is 5 to 10, regardless from the time of, or from the point of view of energy consumption. So I don't think it would need to be adjusted. That's my initial reaction.
We're in added time, Mr. Herman. You can continue if you'd like.
I would. Thank you, Mr. Examiner. Now, one of the, with your answer in mind, one of the goals of the TOD proposal is to send effective price signals to consumers, correct?
Yes, to align the cost of energy with the cost of electricity.
So in the event there were a time change, PNM would only rethink its TOD use rates if they were no longer sending effective price signals?
May I rephrase your question? Are you asking me if that's the only time PNM would adjust the on-peak periods and the off-peak, the various peak periods. Is that what you're asking? I'm sorry.
I'm not asking if it's the only time. I'm just, and again, I apologize for being in the abstract here, but I just am wondering if the TOD proposal should consider that possibility, or if we need to revisit it if there is, a time change like that, and if we'd have to maybe revisit it at that time to see if it's affecting usage throughout the year.
I think certainly everything that impacts the time of day rate design should be revisited as we go along. I mean, the whole purpose of having the pilot is to study the various aspects and how customers shift usage, how they respond to the time signals. And it could be that moving to permanent Mountain Standard Time would impact them, and we should take that into consideration and revise and refine the time of day pilot, especially since we, in the long term, look to open it to all customers and not just have a smaller pilot sample. So I don't disagree.
Thank you for that indulgence. Can I direct you to your rebuttal testimony?
Yes.
Page 18.
Okay, just 1 minute, please. I'm there, Mr. Herman.
Okay, thank you. The first question on that page, starting at line 1 through line 12, you state that ABCWA witness Harriger's proposal is unclear because at the time we were in these discussions, we used rate schedule 4B instead of 11B. Is that a correct characterization of that testimony?
When you say at the time that you were in discussions, you're talking about the settlement discussions from the 2016 case?
Yes.
Yes, that's my understanding of kind of the foundation of Mr. Harriger's example or his explanation for what he was proposing in this case. But 4B is not functionally linked to 11B, so it seemed that it was a theoretical explanation rather than, yeah, I'll just say a theoretical example, like I said.
If rate 11B did not exist at that time, what rate schedule do you think the Water Authority would have qualified for?
If it didn't exist in 2016?
Yes. Would it primarily be either rate 3B or rate 4B?
I don't know. It would depend on what their load was for like 9 months out of the year. So I don't know. I've not thought about it.
Do you know how the on-peak and off-peak rate ratios compare between rates 3B and 4B?
Currently or in 2016?
Let's start with in 2016 and then currently.
I believe that in the settlement talks, that was when the agreement was made to increase the ratios for 11B by doing what Mr. Harriger described in his testimony. And so coming out of the settlement talks or the stipulation, the ratio of on-peak to off-peak for rate 11B was like 7-to-1 or 8-to-1 in the summer. So it was increased much more than the other rate schedules.
I'm sorry, I was asking about, I was still on the differences between rates 3B and 4B. Let me rephrase it and just ask it this way. Would it be reasonable to say that the on-peak and off-peak ratios between rates 3B and 4B are very similar? As
Currently?
today?
Currently.
Yes.
Okay. I'm getting all confused between 2016 and now. Yes. Yes, they are approximately the same, more or less.
Okay. That concludes my questions. Thank you very much.
Thank you.
And I went over about 7-8 minutes, Mr. Examiner, and we can. I'll go ahead and waive my cross-examination for Mr. Sandberg. I had 10 minutes for him.
So it's a waiver now?
Yes.
Okay. Thank you. Thank you, Mr. Herman. Okay, up next is Kroger, I believe. Mr. Boehm, good afternoon.
Good afternoon, Mr. Hearing Examiner.
I have you down for 10 minutes.
Yes, I think I can accomplish that.
Great. Please proceed.
Thank you. Good afternoon, Dr. Pitts.
Hello, Mr. Beam.
I just have a few questions, and I want to refer to your exhibit HMP2, and it might just be most efficient if I share my screen.
Okay.
I'm going to be kind of jumping back and forth between 2 pages from HMP2, or I guess, yeah. So this is the unbundled page. Do you recognize this?
Yes.
So if we look at line 1, column 5, this is for the 3B/3D classes. This shows that the unbundled demand-related costs of service for Schedule 3B is about 103,448,000. Is that correct?
Yes.
Now, if we go to, I'm going to skip to the banding portion of the exhibit. Do you recognize this page?
Yes. Is there any way to make it a little bigger?
I will try. Let's see.
So, Mr. Boehm, the page we were previously on in the PDF, I have page 80 of 397. And what page are you on now?
So I'm on a different. The PDF that I have only goes up to page 175. So this is
That's an exhibit
on my, yeah, it's page 15 on my PDF.
But this is from Dr. Pitts's direct testimony, an exhibit, right?
Correct.
Okay, just go ahead and state a number and I'll find it, because I'm trying to see it on a larger screen here, the exhibit. So
Hearing Examiner, it's page 86 of 397.
thank you.
P&M Exhibit 45.
Okay, there.
My apologies. I'm not sure why mine are different, but yeah. Okay, so you, Ms. Pitts, you recognize this portion of your exhibit?
Yes, it's the banding tab of the rate design model.
Okay, so if we go to line 25, column 5, we see that same number. This is PNM's proposed banded revenue requirement by component for demand revenue recovery, and that's also the 103,488,000. Is that correct?
I think so, but the type is really tiny.
Okay.
Let me pull the computer a little closer, maybe that'll help.
Does that help?
Yes, there, thank you. Yes,
Okay.
that's the same.
Okay, so now I want to go back and talk about the customer component. Now I'm jumping back to the previous page. On line 10, column 5, we see that the unbundled customer related cost for Schedule 3B is about 4.3 million. Is that correct?
Yes.
And if we go back to the last page, we find that same number on, this is PNM's proposed banded revenue requirement for customer revenue recovery, line 34, column 5 is that same number, that 4.3 million, correct?
Yes.
So for customer and demand charges, they're equal to the cost of service is equal to your banded proposed revenue requirement for those components. Is that correct?
Yes, we kept the demand component and the customer component at cost of service.
And so jumping back for the last time to the energy component, we see that the unbundled non-fuel energy related cost of service for Schedule 3B is about $8.1 million. Is that correct?
Yes.
And then jumping back to the banding proposal, line 31, column 5, it's a much higher number now. It's so the proposed energy recovery is about $20.7 million. Is that correct?
Yes.
So you would agree that among the three cost components, demand and energy and customer, energy is the only component recovering more than its cost of service. Is that correct? In your banding proposal?
Sorry to speak over you. Yes, the banding proposal, the subsidies flowed through the energy component.
You filed rebuttal testimony in this case. Is that correct?
Yes.
And you addressed Kroger witness Mr. Bieber's direct testimony. Do you recall that?
Yes.
I'm just going to read a couple sentences from that rebuttal testimony, page 24, lines 18 through 22. You state, if Kroger witness Bieber truly believes that the difference between the on-peak and off-peak energy charges represent demand costs, then under PNM's rate design principles for this general rate case, PNM believes that the appropriate place to recover those costs would be through the demand charge. Do you recall that statement?
Yes, that's in my rebuttal.
To the extent that the commission agrees that the banding adjustment should be recovered through both the energy and demand rate components, is your position that the proposed 3B demand charges should be increased to recover a portion of the banding adjustment?
Well, Mr. Bieber's argument for his proposal was that the true energy cost is reflected in the off-peak energy charge, and the difference between the off-peak energy charge and the on-peak energy charge is an energy premium that represents some demand costs. And that was what he was reallocating, according to my understanding of his testimony, to balance out his proposal of passing the subsidy through the energy charge and the demand charge. And what I was stating here in that paragraph that you read is that PNM disagrees that what Mr. Bieber calls the energy premium reflects demand charges. But if that's Mr. Bieber's position that those are demand costs, then they should be recovered in the demand charge.
So you would agree with the statement that that if the commission agrees that the banding adjustment should be recovered through both demand and energy charges, then demand charges should be increased to recover a portion of the banding adjustment?
What I'm saying is that I don't agree that the difference between energy charges, the off-peak and on-peak, represents demand costs at all. The demand revenue requirement, we believe, is the cost of service for the demand components. And so I don't agree that this on-peak energy premium represents demand costs, is what I'm saying.
If we could just forget for a moment Mr. Bieber's argument about and I understand your disagreement with that. So just if you put that out of your mind and if you just respond to the question of if the commission agrees that the banding adjustment should be recovered from both demand and energy, is it your position that the proposed 3B demand charges should be increased to recover a portion of the banding adjustment?
If the commission were to decide that banding should be applied to the demand component as well for all rate schedules, then yes, I assume that the kind of logical conclusion of that would be that the subsidies flowing to the energy component right now would be spread across demand and energy costs.
Thank you. Those are all the questions. Almost exactly 10 minutes, Mr. Hearing Examiner.
You stole my words from me. Exactly. Good job, Mr. Boehm. Thank you.
Thank you.
Appreciate it. Okay. Mr. DeSalen, good afternoon, sir.
Good afternoon, Mr. Hearing Examiner. Thank you.
I have you down for, go ahead.
I have reserved 36 minutes.
That's
for,
correct.
Cross of Miss Pitts. And Mr. Boehm, could I ask you please to unshare your screen?
Thank you.
My apologies. Thank you.
Oh, that's fine. Thank you. Good afternoon, Dr. Pitts. My name is Charles DeSalen, and I represent the Coalition for Clean, Affordable Energy in this proceeding. And I have a few questions for you. Now, some of the questions that I'm going to ask you, I covered with Ms. Chan, but I'd like to get your perspective on some of the things. And my questions are going to go to your direct testimony, which I believe is PNM exhibit number 45, and also to your rebuttal testimony, which is PNM exhibit number 48.
Which would you like to start with, Mr. DeSalen?
We'll be starting with your direct testimony. And most of it will be from your direct testimony, not that much from your rebuttal testimony. And most of the questions will go to the PNM's proposed time of day rates.
Okay.
So just sort of preliminarily, I understand from your testimony, particularly your rebuttal testimony, that you have read the testimony of the Coalition for Clean, Affordable Energy expert witness, Mr. Michael Kenny. Is that correct?
Yes.
And so you understand that CCAE, and I'll refer to the coalition as CCAE, the CCAE generally supports PNM's time of use rates proposal, but we do propose some adjustments. You understand that?
Yes, sir.
Okay, I just wanted to make that clear. So the first thing I want to ask you about is the limitation on participation. Now, as I understand it, the proposed time of day rate pilot program that the PNM is proposing is limited in that there would be a cap on the number of customers that can participate in the program. Is that correct?
Yes, we have a cap of 7,500 for the residential component of the time of day pilot and 2,500 for the non-residential component, so 10,000 total.
Okay, right. That was my understanding as well. And so I believe that PNM has a total of 370,000 residential customers. Is that correct? Approximately?
No, it's closer to 485,000 residential customers.
Okay, I don't know. I got the 370,000 from the record somewhere, but I will accept your number. But that would mean that the cap that is placed on residential customers, the 750,000, or excuse me, the 7,500 cap is less than 2% of the total residential customers. Is that correct?
Oh, yeah, approximately.
And I also have, and you may need to correct this, but I also have, or my understanding is that you have approximately 180,000 non-residential customers.
No, we have, I mean, there's approximately 550,000 customers. So there's about 60,000, I'll say, non-residential customers.
60,000 non-residential customers. Okay. So
I think,
go ahead.
I think you got the number, the 374,000, because when I was doing the income analysis and looking at usage, I only wanted accounts that had actual usage for the 12 months of the year, so that when looking at average usage, it wasn't skewed by people who moved in the middle of the 12 months or by months with zero usage. And so that's where, in the first part of my testimony, I think that's where you got the 374,000, because that's approximately 75% of PNM's residential customer base. So,
okay, that's quite possible. But my point here is, and the numbers are all sort of ballpark, so it probably doesn't make that much difference. But my point here is that the limitation that you're placing on the number of customers, we're talking 1 or 2%, no more than 1 or 2% of your total customers. Is that correct?
yes, about that.
Okay. And how were those maximum numbers derived?
Well, initially, when PNM started talking about the new time of day structure and exploring options with interveners after the 2016 stipulation, that's when the process started. Initially, the idea was an even smaller pilot. Ms. Chan has, in her February 17th supplemental testimony, all the notes from the various meetings that took place. And initially, back in like 2018, like WRA proposed 5,000 customers. And then in 2019, when we were meeting with stakeholders up in Santa Fe, PNM proposed 5,500 residential customers and 1,500 non-residential commercial customers. And then we extended it more to 7,500 residential and 2,500 non-residential. So it has sort of kind of always been around those numbers, but it actually has increased slightly from when we first started talking about this, or when PNM first started talking about this in 2018. So that's in the discussions and the collaborations, that's sort of how we arrived at these numbers.
Okay, so you didn't do any kind of sort of statistical analysis or any kind of number crunching to try to determine what would be a representative sample of your customers to develop this pilot?
No, we didn't do any statistical analysis. For one thing, it's an opt-in pilot, and so with an opt-in pilot, there's no way to force a representative sample, because we will market and educate and encourage customers to sign up. But again, it's opt-in. And then there's also the consideration, which went into the thinking on the customer cap limits, of the cellular interval meters that will be installed for these participants. And so there's that balance as well of the cellular meters, knowing that there's the pending grid mod AMI case where those would be fully deployed. So it was a balancing act of having enough customers that will provide opportunities to analyze the response to the price signals and the ratios that we propose, while also balancing, the cost of the meters and those considerations as well. So that's what went into the thinking, but not a statistical analysis.
Okay, so you've hit on a number of things that, time permitting, I'll be asking you about in the next few minutes. Now, let me just ask you here, given the limitation on maximum of 10,000 customers, would you agree with me that that has the potential to limit the amount of useful data that the PNM will derive from this pilot?
No, I don't agree with that. I think that PNM will be able to get a lot of useful information from that number. So, no, I'm comfortable with that number.
Okay, but it would have gotten, or it would get more information if the limitation, the limitation on the number of participants were higher, wouldn't it?
If we got enough customers to sign up, and I admit that I'm very enthusiastic about the time of day pilot rate and would love to reach the customer cap limit, because that would mean we had successfully marketed and educated and people were excited about trying out a new rate design, that connects price of electricity to the time that they use it. So I'm optimistic.
Okay. Well, that kind of leads to my next question. What happens if there are more volunteers than 10,000? How will you select out of the applicants, which ones will actually participate in the program?
It would be first come, first serve.
Okay. And then I want to ask you about the control group. As I understand it, the pilot program would include both a group of actual initial participants and then another group of volunteers who are a control group. Is that correct?
Only for residential 1A.
Right, right.
Commercial.
Yes, thank you for that clarification. And the control group would consist of customers, residential customers, who request participation in the program, but who would not be immediately enrolled in the program. They would be enrolled a year later. Is that correct?
They would receive a meter exchange so that they would start having the interval data, and they would receive access to the same energy usage information and the emails, the tools that the time of day rate recipients or the people on the rate get. It would just not, those emails would just not include the time of day coaching, but they would have access to their energy data and energy usage so that they could start to learn about how they are using energy.
Okay, but they would not be offered the time of day rates, correct?
Right, for 12 months.
Right, okay. And then how many customers of the 10,000 potential customers that would be in the program, how many would be initially part of the control group?
My understanding from the evaluation plan is that, I mean, it's somewhat fluid depending on how many people sign up. It's not a one-to-one, like two people sign up, one goes into the control, one goes on the rate. It will be kind of statistically determined to the extent that the DNV can do that, how many go into the control group, but it might be about 2/3, 1/3. So a general rule of thumb, 2/3 on the rate, 1/3 in the control group.
Okay, so you'll sort of make the decision as you go along, as people are submitting requests to join the program.
Well, we won't. I won't. The TOD program manager won't. It will be DNV who is the program evaluator, and they're still working on the final details of the evaluation plan. But the way it would work, for instance, my understanding is that if we have a wait list of people who are interested in the rate, there would be a final order. We would let them know what the final parameters are, the peak hours, the rates, et cetera. Do they still want to participate? They say yes, say there's 100 people on this list. Then we would send those names to DNV, and they would separate them out. We would explain in advance the treatment group with being on the rate versus the control group and the energy usage information that would still be provided to them. We would send the list of names to DNV, and they would separate them out into the control and the treatment group, the rate group. And they would send it back to us, and we would let them know. So that there's no surprises for the customer. We wouldn't just leave it where they don't know if they're on the rate or not. When DNV sends it back to us, we would let them know so that they know what to expect. But
I'm sorry, ma'am, are you saying D as in David, N as in Nancy, V?
V as in Victor. Yes.
D,
sorry.
N as in Nancy, V.
Yes.
Thank
Sorry,
you.
Mr. Lee.
Okay, so that kind of hits on my next question. Maybe you'll have the same answer, but I'll go ahead and answer it. Ask it anyway. So how will your contractor determine, if you know, which customers will be selected for the control group and which customers will be selected to immediately get the time of day rates?
That I mean, the way it was described to me was sort of like a randomized coin toss in a way. And yet I don't know the particulars of how they will separate them out into the control and the treatment group. So I'm not totally sure.
Okay. Okay, then I want to ask you a little bit about how the participants would be selected. The time of day pilot program is a voluntary program, right?
Yes.
So a customer has to request participation in the program?
Yes.
And so the participants are essentially self-selecting, right?
Yes.
And wouldn't you expect that the first customers, and you said that it was first come, first serve, the first customers who would want to sign up for this program would be folks who are probably the most informed about electricity rates and how they work?
Well, we're going to do marketing and education and are developing marketing materials. We're developing a new section on the website with a tool that they will be able to compare a 1A bill with a time of day bill. You know, they have to make some assumptions on the website about how much on-peak usage they might have, what customer behaviors they might think about shifting, things like that. So we aren't going to just leave it unmarketed for only the most informed to find out about. We will be sending out, like, for instance, low income customers, we will send bill inserts, paper bill inserts to the zip codes that are predominantly low income in order to try to target that socioeconomic group as well. So we have banner ads for Facebook. They're developing trifold brochures in English and Spanish to take to energy assistance fairs. There's like ads on various multimedia like Spotify, I forget all the one, Pandora, things like that. So we are going to market the concepts of what it means to have peak usage, off-peak usage, how you can have bill savings. But it's true that people who are more informed about peak periods or the concepts of time of use, or who are like maybe someone who has moved here from a jurisdiction that had more familiarity. I mean, there's all sorts of things that could lead to a customer being more informed and therefore one of the first to sign up. Or they see they have a bigger house, they have air conditioning, central air conditioning, and they think, oh, this is an opportunity for me. So, you know, I don't, yeah, I'll just leave it at that.
Okay, but still, it's going to be the customers who are sort of more proactive, who pay more attention to PNM's rates, who actually read the inserts, who are going to be more likely to sign up for this program. Wouldn't you agree?
Well, they will be more likely to know about the program, but more likely to sign up. I mean, I don't know. The bill inserts are only going to go to low income, predominantly low income zip codes. So those aren't going out to everyone, but the mass media, you know, does go to everyone. And so hopefully it drives them to the website where we explain all the concepts and how to shift usage, what it means to shift usage, suggestions of things that people can shift, and then they apply it to themselves. But it is true that they have to take the first step. They have to be interested and want to learn more, but our marketing efforts can do as much as we can to nudge them to wanting to learn more. So That's my hope.
Okay. Okay. And, but would you also agree that those same people are the ones who would be more likely to change their behavior to minimize their electric usage during peak hours?
Oh, sure. I mean, it's like any early adopter for any technology. You know, the first people who adopted iPhones were different from the people who adopted them at the very end. So yes, I mean, the people who are interested first are probably going to be those that can figure out how to benefit and how to shift their usage first. So yeah, I agree with that.
Okay, so would you agree with me that there will be a certain amount of bias in the data as a consequence?
Well, I mean, that's the reason for a control group, because sure, there's self-selection bias, and that's why the control group, PNM proposes to create the control group out of people who also want to sign up, because they're more likely to be similar. They want to be on the rate. And so to compare the shifting behavior of person A against person B, who also wants to be on the rate and therefore might have more similar characteristics, is important in minimizing bias. I don't think, unless it is a perfectly controlled, like randomized control trial for, you know, like developing a new drug or something like that, that it's possible to completely eliminate bias in creating a new rate pilot like we're doing, but we can try to minimize it. And so that's why PNM has proposed the type of control group that it's proposed, is to be able to measure the energy shifting statistically significant and minimize the bias.
Okay. I'd like to ask you a few questions about the peak hours and how that works. So just quickly, the schedule for the time of day rates is divided between summer months, which is June, July, and August, and non-summer months, which is September through May. Is that correct?
Yes.
And then the schedule is also divided, as we've already discussed a little bit, between residential customers and non-residential customers. Is that also correct?
When you say the schedule is divided, those two groups have different peak hours, yes.
Yes, that's exactly what I meant. And for the summer months, the schedule has one peak period, and that's in the evening. Is that correct?
Yes.
And then in the non-summer months, the schedule has two peak periods, one in the morning and one in the evening. Is that correct?
Yes.
Okay. And I don't, well, first of all, and I asked Ms. Chan this question as well, but I'd like to hear your conclusion. Do you agree that the shifting of two peak periods to one peak period and then back to two peak periods will be confusing for some of your customers?
No, when we developed or first were thinking about the peak periods for residential, the idea has always been to align the cost of energy with the cost of electricity. And so you can see with the graphs in my rebuttal testimony, it's exhibit HMP4 rebuttal, where there's the the graphs of the Palo Verde historic, the last 3 years, the historic prices, and you can see how overlaid with the peak periods, and you can see how there's morning peak and an evening peak. And the evening peak cost of electricity actually, or cost of energy, actually aligns best with the 5 to 10 p.m. on peak period for the non-residential rate schedules. But in talking with customer communications here internally at PNM, they said that it would be that to have the same hours in the morning and evening would be much easier for customers, residential customers, to remember, because we can emphasize 5 to 8 in all of our materials, magnets, just the brochures, the website, everything 5 to 8. And it's kind of like a mantra and you remember it. And then given that there's not a 5 to 8 morning on peak period in the 3 summer months, that means that we need to have outreach as we are approaching a seasonal shift coming up to, like, as we're coming through May, coming up to June, where there won't be a morning peak. We would reach out to customers and have a plan to let them know, whether email, text, we haven't finalized what that would look like, but according to how they want to be contacted, a reminder, right? And then again, as we're coming through August to yet another shift, September, now there's a morning peak, but it's always 5 to 8, and all the materials say that. So no, I think that customers can understand and remember that, but it is one of the reasons that we shortened the summer on peak period from 5 to 10 to 5 to 8 for the residential to match the morning as well.
Okay. Well, let's talk about that some more. You understand that the CCAE expert, Mr. Michael Kenny, recommended that the morning peak be eliminated.
Yes. Okay.
And in your rebuttal testimony, and that's on page 47, you make a reference to the Palo Verde index prices for 2020 through 2022, and which you just referenced. And I'm wondering, is there anywhere in your testimony, in any of your testimony, where you explain what the Palo Verde index is?
I'm sorry, could you tell me what page? I was shifting from direct over to rebuttal. Could you just point me there real quick? But I know that
Sure,
I reference Palo Verde index prices.
Yeah, sure. It's in your rebuttal testimony, and it's page 47, and it's about at line 14.
Yes.
And so I'm not asking you specifically about that section, but I'm wondering if there's any place in any of your testimony where you describe what the Palo Verde index is.
I think it came up in discovery, but I don't believe I described it in a direct or rebuttal. So no, it came up in discovery, Mr. DeSalen.
Okay, and other than discovery, which is not part of the record, is there any place else in the record that we have of this proceeding that you're aware of? And I don't expect you to know the entire record, but anything that you're aware of that explains what the Palo Verde index is?
Well, I've used it, like I was referencing earlier that you mentioned, PNM exhibit HMP 4 rebuttal attached to my rebuttal has the Palo Verde index prices for 2020, 2021, and 2022. And it's a measure of market prices of energy. So that's where you can see that there is a morning peak in the non-summer months for the market price of energy, and then the summer peak for the 3 summer months. But no, I don't,
Right.
I describe it in my testimony, what the Palo Verde
Right.
index is.
Okay, sorry if I interrupted you there, but I did want to ask you about those charts, which is your exhibit attached to your rebuttal testimony, exhibit 4, and I believe that is PDF page. I think it starts on page 72. And then it follows with the next 12 pages. Those are monthly graphs. And Dr. Pitts, it doesn't seem to say anywhere what the source of that information, that data is. And I was wondering if you could explain that.
Well, the Palo Verde index is a kind of a market clearing place for energy. So it's a proprietary database, but this is a compilation over 24 hours. So it's like an average of, if we look at, say, January, hour 1 for every day in the month of January. So it's an average. And it's just a database of market energy prices. So it doesn't represent any one day, it's an average.
Okay. I have a few more questions about this. So first of all, the charts or the graphs aren't labeled. Now, I presume that the horizontal axis, the x-axis, is hours. There's 24 of them. Am I correct by that?
Yes.
Okay, and then the vertical axis, I presume that's some kind of cost function, but I'm not sure exactly what those numbers represent.
Right, it's the cost of energy. So it's not the
Okay.
actual price, it's a relative price. It's a relative scale. So it's not a dollar scale, it's a relative scale.
So what would those units be?
They're unitless. So, it's just a relative, yeah, it's not saying that if something is at 1, that it was $1 per megawatt hour. That's not what it's intended to represent. It's more expensive than energy at the 0.7 level. So that's what I mean by relative, like in comparison. So it's a comparison scale.
Okay, so go ahead, Mr. Hearing Examiner.
Oh, I just wanted to let you know we're ending your cross-examination time.
Yes, thank you.
I don't like to interrupt. I'm sorry, I don't like to interrupt, but so
all right.
forgive me.
No, that's quite all right. And actually, I appreciate it. And I noticed it. And what I'd like to do, Mr. Hearing Examiner, is take 5 minutes from my 10 minutes for Ms. Ramey and use that here because I still have a few more questions.
Ms. Pitts, can you hang in there for another 5? Dr. Pitts, I'm sorry, could you hang in there for another 5 minutes?
Yes, of course.
Thank you. Okay.
Thank you, Mr. Hearing Examiner. So I guess my last question on this issue is, could you explain how these tables are relevant to the case, to the time of day rates that you were applying? But can you make some kind of a linkage there? Because as it is right now, I don't understand how the charts relate to the situation of PNM and PNM's customers and its time of day rates.
Yes, of course. So the goal of the time of day peak periods is to align the cost of energy with the cost of electricity. And so the Palo Verde indexes represent the cost of energy. And so as we were discussing, like if we just look at the January graph, you know, it is the first hour, second, you know, it's 24 hours. And you can see that the prices, this is for 3 separate years, 3 lines.
Right.
The prices rise again, we'll talk about January. The prices rise, and in the morning, the highest peak is around hour ending 8, and then they sink again. You know, you can see that kind of U-shaped, it's almost like a camel, right, in the non-summer months. And then they rise again in the late afternoon hours and decrease again in the nighttime hours. And what we did with this was overlay the proposed residential and non-residential time periods, the peak periods, so that you could see how the peak periods were encompassing to the best of our ability with the constraints, like I was talking about with, say, the residential time of day rate design or peak period design. You can see how the peak periods try to align with the highest peaks in the energy. And so the darker pink stripes are in the non-summer months, it's that 5 to 8 time frame that is the same for residential and commercial customers.
Mm-hmm.
And then in the 3 summer months, you have those 2 extra hours that are kind of light pink shaded, that are hours 21 and 22, which is the 8 to 9 and 9 to 10, those 2 extra hours for the commercial classes. That encompasses those 5 hours in the summer that are the peak period. And you can see it encompasses, when you look at June, July, and August, you can see that it much better, those 5 hours much better cover the highest cost of energy represented by the Palo Verde index prices. And so it was an attempt to show graphically how the peak periods aligned with the cost of energy. So that's the purpose of these 12 the 12 pages in this exhibit HMP4, because rather than just showing one representative month, like one summer month and one non-summer month, we just wanted to show all 12 months and how the energy prices, you know, change month by month, because there is a morning peak in the non-summer months that is not there in the summer months, which is why we don't have or have not proposed a morning peak in the summer months. So that's the purpose of that exhibit, was to align the goals of the time of day pilot.
I guess what I'm getting at in my last few seconds here is how do we know that this Palo Verde index is representative of the rate curves that PNM actually has?
What do you mean by the rate?
No, I misspoke there. I didn't mean rate curves, but the energy use curves. How do we know that your curves, that this is representative of the actual curves that PNM would have?
Like our load curves are how
Yes.
customers are actually using energy?
Yes.
well, I mean, that's not on these graphs because that wasn't the goal of the time of day pilot. We were aligning the cost of energy with the cost of electricity. And so we didn't do a load analysis to overlay that into the peak periods too, because we're looking forward. We do know that when you look at like net load, when the net loads are, the peak net load is occurring, if you look historically over the last 4 or 5 years, there are more and more net load peak hours moving later in the evening. So we do know that confirms the selection of these hours as our peak periods, but it wasn't part of the analysis that initially selected these hours as the peak for residential and non-residential. It was all about wanting to send a price signal to customers that aligned the cost of electricity with the cost of energy.
Okay, thank you, Dr. Pitts. I very much appreciate your answering my questions. And my time is up. Thank you very much, Mr. Hearing Examiner.
Thank you.
All right, Dr. Pitts, we're in recess for the evening as far as you're concerned. So
Okay.
Thank you very much. And we'll see you tomorrow morning at 9.
Sounds good. Thank you all.
Thank you, Dr. Pitts. Okay. Do we have any issues to address? We do, but I'll start with Mr. Gould because I saw him come on first on the panels.
Thank you. My co-counsel, Ms. Gould, should have sent you an email from our 2 witnesses. Brian Andrews is available tomorrow and Greg Meyer is available tomorrow, but he has to be done by 3:30. But I would note.
How about the next day?
The next day.
Which is Wednesday.
No, they are not available on Wednesday. But we do have currently scheduled, of course, Gerard Ortiz and Jim Dauphiné for those days. And right now, those are the days they have open, the day, Wednesday.
Okay.
But I did do a quick addition and it looks like we have at least 5 hours scheduled for tomorrow. So it seems unlikely that you're going to be able to shoehorn these 2 NMA witnesses in.
No, because what our plan was, Ms. Nanazi, was to go if we had a chance to get to Mr. Sandberg tomorrow after Phillips, after Mr. Phillips. Because that's the last, after Dr. Pitts, the last PMM witness is Nicholas Phillips. So what I'm looking to do is to fill in and to end as soon as we can tonight, is to fill in Wednesday. And we have GIGAX. Well, we would probably start with Sandberg, and then we have Cray, and then we go to GIGAX, and Woolridge, Ortiz, and Dauphiné. So it looks like we're pretty full up.
Okay.
In the short term.
I will text these witnesses and tell them they're not on standby tomorrow.
Yeah.
Okay, thank you.
I think that's fair, isn't that, Hearing Examiner Ryan?
Yes.
Oh, is that okay? Let's see. Ms. Beatles.
And my co-counsel is going to be up tomorrow. I have some client meetings that I have to go to. So
okay.
I'll be in and out, but she will be handling the witnesses. Mostly Mr. Phillips is what I'm.
Okay.
Thank you so much. Appreciate it.
Thank you, Mr. Gould. Sounds good. Mr. DeSalen. And then Ms. Beatles after Mr. DeSalen.
Thank you, Mr. Hearing Examiner. Just along the same lines, our witness, Mr. Kenny, is not available this Thursday, but he will be available any other time this week. So, and I will send an email to confirm that.
So it might be possible, Mr. DeSalen, Friday
Okay, that would be
for
fine.
Mr. Kinning, possibly. I mean, so, but I appreciate this dialogue. This is exactly what I was hoping for. Ms. Beatles?
Thank you, Mr.
Did you have your hand up? I'm sorry.
Yes, and I
Okay.
took it down in anticipation that I was next.
I'm sorry.
No, that's
I-
fine.
You know, because I'm looking at all these panels and then I see the hand and then I forget. So apologies.
Oh, no, yeah, no, it's fine.
Okay.
This doesn't help you with Wednesday, but Mr. Brendan Botts is available on Thursday and Friday, in addition to his scheduled day of Monday, a week from today.
Again, perfect. Thank you. That's exactly what I'm looking for in this dialogue over, flexibility. And I have Mr. Yar's hand up. Mr. Yar,
Thank
Good
you, Your Honor. Thank you, Your Honor.
good evening.
Good evening. I just wanted to confirm I heard you correctly that Mr. Cray is not going on Tuesday, tomorrow, but Wednesday.
Looks unlikely
Okay.
unless we catch a break somehow. Because we have still, I sent a note to hearing examiner Ryan. We've got 85 minutes left, it looks like, with Dr. Pitts. And then we have 4 hours scheduled now for Mr. Phillips. And of course, this doesn't include any commissioner or hearing examiner questioning. So that's
Which
where,
there will
and-
be.
and-
Yeah, there will be for Ms. Pitts. I'm confident of that.
Yes. So if we're lucky, we'll get to Mr. Sandberg tomorrow.
Thank you, Your Honor.
Thank you. But Mr. Cray should be, on call just in case.
Okay, I'll let him know.
Thank you. Thank you.
Does that, I mean, Mr. Yars, he is available. I mean, I suppose it'd just be important to confirm either Wednesday or Thursday. I assume that's where he'll get slotted in.
Well, I think what I understood Mr. Madero saying was either Tuesday, it's a 15-minute cross, that's all there is,
Oh,
or
okay.
on Wednesday.
Right.
That's my understanding.
Yep.
Correct. And I see Mr. Alvidrez's hand up. There was another hand that popped up, but that went back down. Mr. Alvidrez?
Yes, Mr. Hearing Examiner, I'm trying to get a little clarification on the lineup for Wednesday, and I know things are fluid. But assuming that the PNM concludes its the witnesses it has tomorrow, the cross-examination of the witnesses, if I understand what you said, we'd have Sandberg, Cray, Gigax, and Woolridge.
Sandberg, Cray,
okay.
Gigax, and Woolridge, and then after that, Ortiz and Dopinen.
Okay, that rounds out the day a bit
But-
more.
Yes, Mr. Gold, could I bother you again?
I do apologize. I was writing an email
No.
to these witnesses, so go, please.
No worries, no worries. Did I understand you correctly that either or both Mr. Ortiz and Mr. Dopine may not be available Thursday, the 21st?
That's my understanding, but I will double check.
Okay, so we may have to switch the order on Wednesday if they're not available on Thursday. We may have to put Ortiz and Dopine or one or the other up first. We may have to switch the batting order on Wednesday, depending on where we are, if they're not available on Thursday.
Yeah, what
So
I
could you
will do, I'll make a commitment. I will call Mr. Ortiz tonight. Mr. Dauphin is an hour ahead, so I am speaking to him tomorrow morning, and as soon as I find out what his availability is, we'll get back to you.
Okay, thank you.
Thank
And
you.
Mr. Alvidrez, sorry, and Mr. Alvidrez.
Oh, I'm sorry, I should put my hand down.
Okay.
Everybody should.
We've gone long, and I want to thank Mr. Lee for going long this evening now. If there's nothing else.
One final
we will-
hand from Mr. Herman.
Thank you, Mr. Examiner Ryan. I was just going to state for your use, my witnesses are generally available any day through Wednesday or Thursday, with a preference for earlier in the morning for Mr. Harriger. But as the schedule permits, they would be more than happy to step up.
Thank you so much again for that flexibility with your witnesses, Mr. Herman. So if there's nothing else, I'd like to go ahead and recess for the evening and bid you a good evening. And we'll see you all tomorrow morning at 9 a.m. for day 9. Good evening, all. We're in recess.
Thank you.
Good evening. Thank you.
Mr. Lee, thank you again.
You bet, Judge.
See you in the morning.
You bet.